What are you doing here, sister?
It's 12:56, you here early.
Yeah.
Where's your chauffeur?
She's going to go into my office and write this month's column. I have no idea.
Yeah.
I didn't ask. Okay.
What are we powwowing about? I think a different, different case.
In June? Is Regina going to be here in person?
No, she's at the Supreme Court.
Supreme Court or us? What's more important?
He says Supreme Court or us, what's more important?
Well, I was kind of hoping that you were going to move it so that I could go to the Supreme Court and then come here. I wanted to hear that argument. If I had more than one attorney, then she would definitely be here.
I'm doing, well, what I'm doing.
It's too late now.
No, I'm getting up. I'm just talking time.
Been a while. Good, boy, I forgot to put a time.
Oh, you're tired.
Yeah, well, I think it's 1 o'clock basically. I got 2 minutes to put it on, so. You need now? I got 12:58, I already have 12:59 now. Good afternoon, everyone, and welcome to the November 17th Delaware Public Service Commission meeting. We have people on the telephone. So the people on the telephone, would you kindly look at your electronic device and put it on mute at this time so that we don't have any interruptions? And secondly, the people who are participating today, please speak directly into the microphone as possible. And I know that I'm aware that we've all been doing Zoom for such a long time, I forgot to wear my tie today. Realized that too late to put it on. But welcome everyone to the meeting. And we have the reading of the meeting minutes first, October 27th. Does any commissioner have any corrections or changes to those meeting minutes? Commissioner Drexler.
I move approval of the October 27th meeting minutes as presented.
Commissioner Conaway?
Second the motion.
Commissioner,
Okay, well, I think maybe a good thing to do is, I know that there's three of us here. Commissioner
I'm
Korea?
waiting to see.
Commissioner Korea, are you out there? Commissioner Gray?
Yes, I'm here, sir.
Commissioner Gray?
yes, Mr. Chair, I'm here. Can you hear me?
Yes, sir, we can hear you loud and clear, thank you. So
Thank
we'll-
you.
We'll continue with the vote. Commissioner Korea?
Mr. Chairman, I'm here.
Good. Could you say either aye or nay with respect to whether or not you approve the meeting minutes?
Aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
Commissioner Gray?
Aye.
And I vote aye as well, that the meeting minutes are approved. The consent agenda, we have 9 items on the consent agenda. Does any commissioner wish to have any item taken off and placed on the regular agenda? And Commissioner Conaway,
Move that we adopt the consent agenda as presented.
I second.
is there any discussion on the motion? Hearing none. Commissioner Korea?
Aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
Commissioner Gray?
Aye.
I vote aye as well. The consent agenda is approved. We are now on the regular agenda. And the first thing on the regular agenda is in the matter of the application of Delmarva Power and Light Company for an increase in electric base rates and other miscellaneous tariff changes. I think we're all pretty familiar with this case. And I guess we have Mr. O'Brien to explain the order.
Thank you, Chair Winslow and Commissioners. Bill O'Brien, Commission Counsel in this matter. So what you have before you is
Electric base rates and other miscellaneous tariff changes. I think we're all pretty familiar with this case.
we may need everybody on the line to mute so that we don't get the feedback loop. But let me start over. We do have proposed order number 9893, revising order number 9863 before you. But I do have one change to make. As you recall, when we last met, I did present you with a proposed order memorializing your earlier vote regarding the warning to Delmarva concerning the violation of the MFRs. And so at the last meeting, you clarified that you meant any violation of any MFR could result in a warning as opposed to just the one MFR that was at issue in that case. So we made that change, but also if you recall during deliberations, there was some confusion regarding the order 9893, revising order 9863, and then a separate revised order 9863. So in order to clear up that confusion, all we have today for you is order 9893, revising order 9863. We don't have a separate revised order, and this should be sufficient in Delafile, sufficient notice that that order had been revised. However, I just noticed as we're sitting here that we did fail to remove the last whereas clause in this order, which refers to the other revised order, which we are no longer doing. So with your permission, I would ask that when you vote on this, you vote to adopt this order with the last whereas stricken, and I will get a copy here for you before you need to sign it. There is one more thing I need to remind the commissioners of, and I've been advised by staff that based on abstentions and absences earlier in this case, that only Chair Winslow, Commissioner Gray, and Commissioner Drexler should be voting on this order. So I will say that all the parties have agreed to the language in this order, and they can speak now if they object to me taking out that last whereas clause, but I did get reluctant consent from all the parties that we not have a separate physical revised order 9863 in order to clear up the confusion from the last meeting. So at this time, I would ask that you vote on proposed order number 9893, revising order number 9863, with the last whereas clause stricken. Thank you.
Thank you, Mr. O'Brien. Mr. Drexler? Or, I'm sorry, is there a Delmarva Power and Light, Mr. Jordan?
Good afternoon, Your Honor. May it please the Commission, Brian Jordan for Delmarva Power and Light. And I do want to take just a moment to thank the Commission for all of the time and the effort that it has devoted to this issue. And I also want to thank staff, and particularly Mr. O'Brien, for cutting the Gordian knot here and getting this order together and getting it ready for the Commission to sign. Thank you.
Thank you, Mr. Jordan. Mr. Slater?
Thank you, Commissioner. We have nothing else to add other than what Mr. O'Brien has already stated. Thank you.
Mr. Walsh?
Chairman Winslow, thank you. Tom Walsh, Deputy Attorney General for staff, and we are in agreement with Order 9893 as submitted and with the last whereas clause stricken.
Any questions, Commissioners? Commissioner Gray, any questions? Commissioner Correa?
No questions. Yes.
Mr. Chair, Commissioner Gray here. If you can hear me, I move that we adopt order number 9893 as edited with the last whereas clause removed.
I second.
I second the motion.
You can't.
Who's the Commission's attorney for right now on this matter?
I am Chair
Mr.
Winslow.
Bryan, right? Because of the governor's order and the emergency order, are the commissioners allowed to be voting remotely?
Yes.
Okay. I thought so, but I was
Yes,
sure.
but in this matter, I would ask that Commissioner Correa refrain from voting or seconding the motion.
And I second the motion.
Is there any further discussion? Thank you for eliminating the confusion. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Commissioner Correa.
Aye.
Commissioner
Aye.
Correa, we're trying to eliminate the confusion, my friend. You're not supposed to be voting.
I voted aye. Aye.
Okay, we will ignore your aye. Commissioner Conaway?
I abstain.
Commissioner Conaway, okay, you abstain. Commissioner Gray?
I vote yes, Chair.
Okay, thank you. The motion carries. But I guess, is it appropriate for me to make a comment about that case now? I mean, there's an appeal. I guess there's no one's going to appeal, right? It's been sort of resolved. I would just like to, Regina could not be with us today. She's arguing before the Supreme Court. But I did want to make a comment about her 25-page brief on the remaining issues, which I thought was an absolutely excellent brief, and I have now given it the name of the $1 million brief. Okay, let's go to number 2 on the regular agenda, which is in the matter of the application of Artesian Wastewater Management and Middlesex Water Company for approval of sale and acquisition of Tidewater Environmental Services. And we have the parties here. And gosh, I guess who's on the line to go first? Mr. O'Brien.
Thank you, Chair Winslow and Commissioners. Again, I am Commission Counsel in this matter, and the reason why I volunteered to go first is because I was tasked with putting together a proposed order memorializing your vote from October 27th. The reason why you could not use the order that was presented on that day was because there was a late intervention in the matter by the town of Milton, and of course the arguments made by the town of Milton and the responses there too needed to be put in the order. So we did draft the order, circulated amongst the parties. There was a lot of give and take on the language. I do believe in the end we came to an agreement that the proposed order 9909 that you have before you today is appropriate and accurate as far as reflecting the vote and the deliberations. But I will let the other parties who are here today speak to that themselves. But in the end, we would ask that you, or I would ask, that you adopt proposed order 9909, which memorializes your October 27th vote, which approves the proposed acquisition and also grants the town of Milton's intervention request. Thank you.
Thank you, Mr. O'Brien. I guess who's going to go first now?
Ladies first. Good afternoon, Chair and Commissioners. Artesian Wastewater agrees with the form of order and respectfully requests that the Commission enter proposed order 9909 that is in front of you.
Identify yourself for the record,
I'm
please.
sorry, Courtney Emerson for Artesian Wastewater.
Mr. Cooper.
Good afternoon, Commissioners, Mr. Chairman. Jay Cooper here on behalf of Tidewater Environmental Services, Inc. Tessie concurs with Mr. O'Brien's representations and with Ms. Emerson's statement.
Mr. Nutter, are you speaking?
I'll defer to Mr. Cooper. Mr. Chair, thank you.
Okay. Is there anyone here from the town of Milton, representing Milton? Commissioners, do you have any questions of the parties? May we have a motion?
I move that we approve order number 9909 as presented.
Second the motion.
Is there any discussion on the motion? Commissioner Correa, how do you vote, sir?
Aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
Commissioner Gray?
I abstain, Mr. Chair, consistent with my vote in the last session.
And I vote aye. The motion carries. Thank you all very much.
Thank you.
Number 3 is in the matter of the application of Tidewater Utilities, Inc. for approval of the issuance of long-term debt obligation. And we have Ms. Toner for Tidewater.
Correct.
Please proceed.
Good afternoon, Mr. Chairman, members of the commission. My name is Sarah Toner. I'm with Richards, Leighton and Finger in Wilmington, Delaware, and I am representing Tidewater in this proceeding. With me on behalf of Tidewater is Kirsten Higgins. The proceeding concerns the application of Tidewater that was filed October 21st with the commission for the approval of a loan from the Delaware Drinking Water Revolving Fund, SRF as they're called. The term of this loan would be 20 years at a fixed interest rate of 2%. As set forth in the materials and applications submitted to the commission, the purpose of the loan is to fund the construction of a 1 million-gallon elevated storage tank, which will be located on Route 24 at the Beacon Middle School in Sussex County. The tank will meet the needs of the customers who live in Tidewater's Rehoboth district. This includes the town of Lewis and Rehoboth Beach. This is actually Tidewater's largest service area. Construction of the new tank will alleviate system pressure during peak summer demand, improve fire protection, and provide redundant storage should a tank be out of commission. As set forth in the application and the materials submitted to this commission, during construction, payments will be interest only, made on a semi-annual basis. Upon completion, the loan will begin to amortize and payments will continue on a semi-annual basis, but will include principal. Again, staying at that fixed 2% rate. Tidewater has made use of these SRF loans in the past, and this is consistent with Tidewater's overall finance strategy of entering into long-term debt at low interest rates. I'm here as a result of the provisions of Delaware law, specifically Title 26, Chapter 215, and its corresponding administrative code provisions that require the approval of this commission before a loan can be entered into. Also included with the October application was a form of legal opinion. It's an opinion that would be rendered by Richards, Leighton and Finger. It's in draft form currently, but the code regulation requires that the loan facility in this transaction be opined by third-party counsel as to its enforceability and legality. We will, as we have consistent with past practice, render that opinion on the closing date and submit it within 15 days of the closing to the commission. In addition, the standard that's relevant with respect to your approval, as set forth in the statute, is based on before a regulated utility can enter into long-term indebtedness, is whether it's in accordance with law, in the public interest, and is for a proper purpose. Based on the application and this, what we've proffered for the record today, we respectfully request that the commission approve entry into the loan and enter the order, which I believe has been previously circulated by the commission staff. Happy to answer any questions, but at this point, I'll conclude. Thank you.
Thank you, Ms. Turner. Mr. O'Brien, on behalf of staff?
Yes, thank you, Chair Winslow and Commissioners. Bill O'Brien on behalf of Commission staff in this matter. And staff agrees with Ms. Toner's summary of the application and the proposed order. Staff did review the application. That review was led by Shona Marshall, a public utility analyst with the commission. She did submit a memorandum with her findings and recommendations dated November 4th, 2021. And that has been provided to the commission. As Ms. Toner mentioned, the proposed order was circulated amongst the parties without objection, and so staff does ask that the commission enter proposed order number 9921, which approves the issuance of long-term debt for Tidewater Utilities as set out in their application. Thank you.
Thank you, Mr. O'Brien. I don't believe, Mr. Slater, you have anything?
I do not have anything to add. Thank you.
Okay, thank you. Mr. Walsh, is under the law, is Richard Leighton and Finger a third-party independent party when they're acting as counsel for the applicant?
That is an interesting question, and if they are the applicant's lead counsel in this, I don't know that they could also be, I question that they could be independent as the proponent. So I think my answer is probably no. It seems to be standing on both sides of the fence, so to speak. I don't know. I think in other 215 applications, we've had other counsel from a different firm than the proponents, or applicants, I should say, submit that.
It sounds to me like Richard Leighton and Finger has done this in the past because the commission has permitted it.
Yeah.
So Ms. Turner, we'll have her give us the explanation.
Yeah, I'm happy to confirm that Richards, Leighton and Finger has appeared before this commission for, I think, at least the 16 years that I've practiced, and then we have subsequently then closed the loan. As an opinion giver, I think that we are able to, the role of an opinion giver is to apply the law to the to the requested opinion, and we have done that consistent with standard and customary opinion practice in the state of Delaware. The form is been accepted by the SRF in previous times, and they are also represented by independent counsel. Is it Ballard Spahr, or I can't remember the law firm that represents SRF in connection with it. But we've never had any trouble whatsoever with respect to our role as opinion giver and appearing here. So I think based on experience and the law, there's no concern. Obviously, I'm going to say that, right? So it'd be tricky to hear today, though, that we're not able to do it when we've been doing it consistently for
Well, it would be
15 some odd years.
It would be the crime to take 2% money out of the hands of Tidewater, right?
And Chairman, I might add, notwithstanding the answer I gave as I was thinking about it, I believe Mr. Nutter has done this, that as counsel for the applicant, also given that independent evaluation. So I think, I don't know that the statute is explicit as to that? It might be part of the regs, in which case certainly the commission has the discretion under the regs to accept that as the independent evaluation.
I'm going to accept Ms. Turner's representations. The commissioners, do you have any questions of the parties? Commissioner Drexler?
Yes, I have a question. What is the term of construction, the time frame?
Hi, my name is Kirsten Higgins, Vice President with Tidewater Utilities. Construction is about a 9 to 12-month process.
Okay, thank you. So that amortization starts in year 2, it sounds like then, of
Yes,
the principal?
It starts after the construction is complete.
Right. Is any of the $5 million carrying cost for that loan during that construction period, or it really costs $5 million to build that?
I do not know that answer, but I can get back to you.
Okay.
I believe it is just the construction costs.
That's expensive to put up one of those.
It's very expensive to build water tanks, yes.
Those
Okay,
thing-
thank
those
you.
things-
Thanks.
Those things are mighty big. You couldn't drink all that water. No way. Does anybody have a motion with respect to this matter?
Move we adopt proposed order 9921 as presented.
I second.
Is there any discussion on the motion to approve this order? Hearing none, all those in favor, okay, let's go. Commissioner Correa,
Aye.
Commissioner Conaway,
Aye.
Commissioner Drexler,
Aye.
Commissioner Gray,
Aye.
and I vote aye as well. The motion carries. Thank you very much.
Thank you.
Okay, we do have a few more things on the hearing schedule. So those who are scheduled for the first matter, please come up to the table. And we're going to have, apparently, a good number of people are here to speak on this matter. I see we have our friend Tom Noyes was out there. I guess he's going to do some speaking, and there are other people. I would just ask that when you come to the table to speak, if you would be kind enough just to lean forward and talk into the microphone so everyone out there can hear you. And I will just remind everyone out there who's listening to please make sure they're on mute.
Yes, this is number 1.
Okay, well, I'm getting them ready for it. You know, you got to anticipate these things. So I just anticipated maybe by a case too early, so.
Primer.
Commissioner Correa, you're getting me confused. So this is Dawn Kurtz-Crompton's matter to start off with.
Thank you, Chair and Commissioners. Dawn Kurtz-Crompton on behalf of Delmarva Power and Light Company. This is Delmarva's annual application to establish the electric standard offer service rates for the period of June 2021 through May 31, 2022. This includes establishing tariff rates for standard offer service supply, which includes the procurement cost adjustment and the reasonable allowance for retail margin components. Delmarva thanks the other parties for their efforts in this docket and thanks staff for preparing the staff memo and proposed order 9923. We also appreciate the opportunity to comment. It is Delmarva's position that order 9923 should be approved. I'd like to get some housekeeping out of the way up front. We do have an exhibit log, which has 4 exhibits. I thank Mr. Walsh for preparing this. The exhibits have been agreed upon by the parties, and they are as follows. Exhibit 1 is Delmarva's application. Exhibit 2 includes affidavits of publication as filed by Delmarva, dated May 4, 2021. Exhibit 3 includes public notices and an affidavit of publication as filed by staff, dated October 14 and October 15, 2021. And lastly, Exhibit 4 is the staff memo for this docket, dated October 25, 2021.
All of those exhibits are entered into the record per stipulation and without any objection.
Thank you, Chair Winslow. Delmarva does have one witness that we would like to provide testimony today. I have Bob Cohen here. May he be sworn in, please?
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Can you please state your full name for the record?
Robert J. Cohen,
And Mr. Cohen, by whom are you employed?
PHI Service Company, primarily on behalf of Delmarva Power. My business address is 500 North Wakefield Drive, Newark, Delaware, 19702.
And in what capacity are you employed by?
Senior rate analyst.
Thank you. How long have you been in this position?
9 years in this specific position, but I've been with the family of companies for over 40 years, doing mostly utility accounting.
Great, thank you. What is your educational background, Mr. Cohen?
I have a Bachelor of Science in Accounting from the University of Delaware.
And were you involved in the preparation of this filing that was submitted to the Commission on March 26, 2021?
Yes, I am primarily responsible for this filing.
And can you please explain the purpose of this filing?
The purpose of this filing is to establish the electric standard offer service rates for the period of June 1st, 2021 to May 31st, 2022. This includes establishing tariff rates for standard offer service supply, which includes the procurement cost adjustment and the reasonable allowance for retail margin components. The revised rates include estimates for the projected period, plus prior period true-ups for any over or under recovered balances.
Thank you. And what was the filing composed of?
The filing was composed of revised tariff sheets, PCA calculations, SOS supply rate calculation, bill impacts, RARM rate calculations, and supporting work papers.
And was the methodology consistent with prior years?
Yes, and in addition, as noted in order number 9733 in docket 20-0236, Delmarva staff and DPA have been working to clarify certain aspects of the settlement agreement, including Exhibit A, contained in order number 7703 from PSC docket number 09-9. Together, the parties have been preparing an amended settlement agreement that will better align with current practices, as well as add consistency and eliminate ambiguity.
And in connection with this filing, did you schedule a meeting with PSC staff and DPA to review all of the documents associated with the filing?
Yes, we held a technical conference via video conference on June 8th, 2021, and later answered both formal and informal discovery questions.
Did PSC staff or DPA propose any adjustments based on the documentation included in the filing?
Staff and the company have agreed to de minimis RARM expense adjustments. 2 invoices totaling $1,875 will be transferred to Renewable Portfolio Standards expense. A 3rd invoice of $561.88 will be transferred to another jurisdiction. These adjustments will be included in the planned March 2022 annual filing.
And thank you. Was notice of this publication published as required?
Yes, on May 4th, 2021.
And were affidavits of publication filed with the Delaware Public Service Commission?
Yes, on May 13th, 2021.
Are these rates currently in effect, Mr. Cohen?
Yes, these charge rates were put into effect on a temporary basis effective June 1st, 2021.
And has staff determined that the commission should approve as final the rates that went into effect on a temporary basis on June 1, 2021?
Yes, as set forth in their memo, staff recommends that the commission approve the temporary rates as final.
And can you please tell the commission what the bill impact to customers is as a result of this filing?
A typical residential customer using 845 kilowatt hours per month on average has seen a decrease of approximately $1.79 per month, which is a 1.61% decrease when including the delivery and supply portions of the bill. To be clear, should the commission elect to enter proposed order number 9923, the rates currently in effect will not change and will not decrease any further.
Thank you, Mr. Cohen. Does this conclude your testimony?
Yes.
And Delmarva offers Mr. Cohen for cross-examination.
Are there any questions of Mr. Cohen?
No questions.
No questions.
Mr. Cohen? Helen, I didn't realize you were a Blue Hen.
Yes, yes. Lifelong Delawarean.
That's good. Thank you for your 40 years of service. Mr. Walsh?
Thank you, Chairman and Commissioners. Tom Walsh, on behalf of staff. We have two witnesses in this matter. I would first like to call Ms. Jenny Board and ask that she be sworn.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Could you please state your name and address?
My name is Jenny Board. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And who is your current employer and what is your position title?
I'm employed by the Delaware Public Service Commission as a public utility analyst.
And what is your educational and professional background?
I've earned a bachelor's degree in accounting and a master's of business administration. I've worked in the financial and regulatory industries for the past 14 years, which includes but is not limited to the analysis of various financial documents.
Could you please describe the basis for this proceeding?
On March 26, 2021, Delmarva filed the application for approval of the 2021 Standard Offer Service Rates, including the Procurement Cost Adjustment, referred to as the PCA, and the Reasonable Allowance for Retail Margin, referred to as the RARM. According to the company's worksheet, the annual average monthly bill for a residential customer using 845 kilowatt hours would decrease by approximately $1.79, or 1.61%. The Commission approved the proposed rates on a temporary basis with proration, subject to refund in order number 9786, dated April 21st, 2021.
Thank you. Was public notice properly published, and did you receive any public comments pertaining to this application?
Yes, the notice was published on May 4th, 2021 in the Delaware State News, the News Journal, and the Cape Gazette. Staff received no petitions for intervention, public comments, or objections before the June 25th, 2021 deadline for such filings. The Delaware Division of Public Advocate filed its statutory notice of intervention on April 22nd, 2021.
And what is your role in this docket number 21-0199?
I reviewed the Procurement Cost Adjustment Rate, or PCA, and the Standard Offer Service, or SOS, fixed bid price component for this filing. The Reasonable Allowance for Retail Margin, or RARM, was reviewed by staff analyst Samuel Kane.
And what was the nature of your review?
I reviewed the calculations and work papers related to the PCA for the period of January 2020 through December 2020 and audited 2 months of actuals. I also reviewed the SOS fixed price calculations and components of the winning tranche bids, as well as the forecasted megawatt hours, to verify the full requirement cost per the summer and winter seasons, rate class, and forecasted billing requirements.
And what is your conclusion as to the company's calculations and its application?
I found no errors in the calculations of the PCA or SOS fixed price components. The fixed price component of the rate is consistent with the winning bid prices that were reported by the Commission's consultant, Liberty Consulting.
And what are your recommendations for the Commission?
Because staff did not find any reason to recommend denial of cost recovery, I respectfully recommend that the Commission approve, as final, the rates that went into effect on a temporary basis on June 1st, 2021, with proration for the period from June 1st, 2021 to May 31st, 2022.
Thank you. And do you believe that your recommendation will result in rates that are just and reasonable and in the public interest?
Yes, staff found the rates and tariff changes to be consistent with previous orders, which were approved as being just and reasonable and in the public interest.
Does this conclude your testimony?
Yes.
Ms. Board is available for cross-examination. Any questions from the Commission?
Are there any questions, Ms. Kurtz-Crompton?
No questions from Delmarva.
Mr. Slater? No questions. Commissioners? Next witness, please, Mr. Walsh.
Thank you, Chairman. Mr. Samuel Kane is going to join us here in a minute. and I ask that Mr. King be sworn, please.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Mr. King, could you please state your name and business address?
My name is Samuel Kane. My business address is 861 Silver Lake Boulevard, Cannon Building, Suite 100, Dover, Delaware.
And who is your current employer, and what is your position title?
I am employed by the Delaware Public Service Commission as a public utility analyst.
What is your educational and professional background?
I have a bachelor's degree in economics from the University of Florida, and I've been an analyst with the commission for a year now.
And what was your role in docket 210199?
I reviewed Delmarva's Reasonable Allowance for Retail Margin, or RARM, which is a component of the supply rate. I reviewed prior orders that pertain to the RARM and audited 2 months' worth of invoices pertaining to the RARM true-up of incremental expenses. I also participated in Delmarva's technical conferences and issued discovery questions. The RARM rate factor temporarily went into effect as part of the standard offer supply rate on June 1st, 2021, per order number 9786, pending review and commission approval.
Can you briefly describe what the RARM is?
The RARM is a rate factor included in the standard offer service supply rates to allow Delmarva to recover the administrative and incremental costs to serve as the provider of last resort, also known as the standard offer service provider. Additionally, the RARM allows Delmarva to earn a $2.75 million margin in accordance with Commission Order 6746. Delaware is a retail choice state, so ratepayers have the option to shop for third-party electric suppliers. If a ratepayer is in the Delmarva service territory and they do not choose a third-party supplier, they default to the standard offer service for the supply portion of their electric bill. A few examples of expenses included in the RARM rate factor are the Commission's technical monitoring consultant contract, a cash working capital requirement, and uncollectible expenses attributed to electric supply, among other incremental expenses.
And what did you find as part of your analysis?
In my review, I found several expenses that were accounted for incorrectly. Delmarva included $1,875 in costs to RARM expenses when they should have been included in the Renewable Portfolio Standards administrative expenses. Taking out this expense does not materially change the current RARM factor, and therefore this correction should be reflected in the next SOS PCA RARM filing. Additionally, Delmarva included $516.88 in RARM costs for professional services to DPL Delaware, when this should have been charged to DPL Maryland ratepayers. This will be reversed in the next filing. This correction does not impact the rate factor as presented in the filing. The previous RARM rate was .000334, and the new RARM rate is .001768, which represents an increase of 429.34%.
An increase of 429% in the RARM factor sounds rather large. What was Delmarva's reasoning behind the RARM rate increasing by that amount?
Delmarva attributed the increase primarily to 2 factors. First, when last year's RARM rate went into effect, there was an existing $3.9 million overcollection for RARM recovery due to the tax change with the Tax Cuts and Jobs Act. With the current filing, there is an undercollection of $177,248.15. In addition to this, the 3-year average of net uncollectibles went from $10,000 to $1.7 million due to a large increase to actual uncollectibles during 2020 and a large decrease in late payment revenues.
And what are your recommendations for the Commission?
Based on my review of the information and data provided by Delmarva, I respectfully recommend the Commission approve the 2021 SOS rates, which encompass the RARM rate factor along with other components. This SOS rate went into effect on a temporary basis on June 1st, 2021, and is effective until May 31st, 2022, conditioned on Commission's approval.
And do you believe your recommendations will result in rates that are just, reasonable, and in the public interest?
Yes, I do.
Does this conclude your testimony?
Yes.
Mr. Kane is available for questions.
Thank you very much, Mr. Walsh and Mr. Kane. Mr. Kane, how many individuals or customers are involved in the RORM and under the supply rate?
All Delmarva ratepayers who elect the standard offer service, fixed service contract are affected by the RORM rate.
Okay. And is the RORM rate, the only place that's found apparently is just in the supply rate?
Yes, that is correct. It is a component of the supply rate.
Okay. Do you know what approximately an individual consumer is paying under that rate?
When isolated on its own, the monthly bill impact of the proposed RORM rate factor change results in an increase of approximately $1.21 for a typical residential customer using 845 kilowatt hours on a monthly basis. However, I would like to point out that this is only a portion of the supply rate, and this change does not change the net, which, just stating another way, is that the RORM rate is only 3% of the total SOS kilowatt hour rate, and the figure quoted by Ms. Board and Mr. Cohen still stands that there is a net decrease of $1.79 per month.
Any commissioners have any other questions of Mr. Kane? Parties, you have any questions of Mr. Kane?
No questions, thank you.
No questions.
Mr. Walsh, thank you very much. Mr. Kane, very well done. Thank you, sir. And may we have a motion, Commissioner Conaway?
Move that we adopt proposed order number 9923 as submitted.
I second.
Is there any discussion on the motion to approve the order number 9923? Hearing none, all those, let's go with Commissioner Correa. How do you vote, sir?
I vote yes.
Commissioner Conaway.
Aye.
Commissioner Drexler.
Aye.
Commissioner Gray.
Aye.
And I vote aye as well. The motion carries. Thank you, everyone. That concludes the just, I see Mr. Nichols out there. He's been chomping at the bit, as everybody is, because we want to hear this next case. And that is, number 2 is in the matter of the adoption of rules and regulations to implement the provisions of 26 Delaware Code, Chapter 10, relating to the creation of a competitive market for retail electric supply service. So would all the parties please come to the table? I guess maybe they are already at the table. And Mr. O'Brien, do you want to give an opening to this application so we can know which way we're going?
Yes, thank you, Chair Winslow and Commissioners. Bill O'Brien on behalf of staff in this matter. Today is the public hearing on the Commission's proposed regulations relating to community energy facilities, or CEFs, pursuant to Senate Bill 2. As you are aware, CEFs were permitted prior to Senate Bill 2, but Senate Bill 2 removed several barriers to the program. Because of those changes, the stakeholders expect that CEF development will really take off after the new CEF requirements take effect. On September 15th, in order number 9883, the Commission approved a proposed regulation, and staff published notice of this proceeding in the Register of Regulations and 2 newspapers. 12 organizations and individuals submitted comments on the proposed regulations. Based on those comments, staff made minor changes to the proposed rules in numerous areas, mostly clarifying in nature. Staff posted those changes to the agenda last Wednesday in red line and as a clean copy. Staff also provided the commissioners with the redlined and clean copies. At the end of the hearing today, staff will ask the Commission to accept those changes to the proposed regulation and find that they are a non-substantive matter under the Administrative Procedures Act, or APA. If the commission makes that finding, we won't need to republish the regulation as a new proposal, which would start the APA procedure over again. Also, as noted in your order number 9883, the commission needs to leave the record open for any additional written public comment for 15 days following this hearing, which is a requirement of the APA. In light of this requirement, the notice for today's hearing included a December 2nd, 2021 final deadline for written comment, but stated that to be considered at today's hearing, the comments must be submitted by November 1st, 2021. So in light of the extension of the public comment period to December 2nd, this matter will be placed on the agenda at the commission meeting following December 2nd, which is now scheduled for December 22nd. At that meeting, we will address with the commission whether any additional public comment was received by December 2nd. In the event that there is no further public comment, or if there is further comment but staff does not believe the additional comment warrants another revision to the proposed regulation, then staff will have a proposed order for your consideration at that time, memorializing your vote today. Staff has one witness to call, Pam Knotts. So if it pleases the commission, I will call her to the stand at this time.
Mr. O'Brien, just before you do that, Mr. Walsh, do you represent us on this matter, I believe?
Yes, Chairman Winslow, I do.
Okay, is there a deadline for us to act on this matter?
If this is, there is not a deadline as far as you can certainly publish a second time if that's what you care to do. I mean, if you're talking about the deadline for the registrar.
Talking about the deadline set by the legislature.
Typically for the 5th. I don't know,
Mr. O'Brien?
I can address that. And Chair Winslow, good question. We will be addressing that in our testimony, actually. But yes, the Senate Bill 2 did provide a deadline of March 11th, 2022 for the commission's promulgation of these regulations.
And it would be fair to say that there's a lot of people here who are very sharp people and interested in this topic. So there's some likelihood that we'd make some change per their suggestion as today's hearing. What impact would that have in terms of making the aforementioned deadline?
Chair Winslow, if it's a substantive change to the proposed regulation, then we would start the APA process over again. And depending on how all the dates fall regarding publication in the Register of Regulations, regarding commission meetings, there would be a substantial chance that we would miss that deadline. Senate Bill 2 did say that that was the deadline unless changed subsequently by law.
Okay. So I guess my thought, and it's nothing more than something I want to put on the table, is whether or not we, after hearing from everybody, because we want to hear from everybody, at the end of the day, if there are some changes that we should consider or do consider when we want to change them, and they would be a substantial change, can we sort of have our cake and eat it too in terms of making the deadline yet still retaining the application or a new application to address the issues that aren't decided today?
Commissioner Winslow, I think that concept would apply to many of the proposed changes that we may hear about today. Certainly staff's position is that the proposed regulation as it sits right now is in the public interest and tracks Senate Bill 2 accurately. I will say this though, there is one objection that we might hear today from the public advocate that would have a significant impact on the on the success of the CEF program and whether or not it even goes forward. And perhaps we can hear about that from some of the solar developers today. But certainly if that were an issue that were still left out there, we might want to hear from the solar developers on whether that would provide too much risk for them to even move forward under the proposed regulation. So there might be one exception to your idea that we can just move forward with these regs and change them later.
Mr. Walsh, you want to make any comment? I don't want to leave you out of the discussion.
No, I think that comports with my understanding of it.
Mr. Slater, any comments? I'm just,
I'm happy to start making my comments. It sounds like you've already heard my comments from staff, but I'm happy to make my comments whenever you deem appropriate.
okay, well, we're going to start with staff right now, and obviously, we're looking forward to hearing from the public advocate as well. Mr. O'Brien, you want to start with staff, please?
Yes, at this time I'll call Pam Knotts to the stand, and I would ask the court reporter to please swear in Ms. Knotts.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name and business address for the record.
My name is Pamela Knotts. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And what is your occupation?
I'm the Senior Policy Advisor for the Delaware Public Service Commission.
And please describe your professional background.
I have a bachelor's degree in business administration, and I have certifications from several different learning institutions, including the University of Michigan Business School. I've been a senior policy advisor with the commission for almost a year, and before that I held positions as a regulatory policy administrator and a public utility analyst. And I've been with the commission for over 14 years and have testified in different regulatory dockets as well as regulation dockets.
And did you lead staff's efforts in this proceeding, drafting the proposed regulations relating to community energy facilities?
Yes, I did.
Please describe the origin of the proposed amendments to the Commission's rules relating to community energy facilities.
On September 17th, 2021, the Governor of the State of Delaware signed into law Senate Bill 2, which amended Title 26 of the Delaware Code, and it accelerated the adoption of the community-based solar photovoltaic systems in Delaware. In addition, Senate Bill 2 established a regulatory process to be implemented by the Commission relating to the community-owned energy generating facilities, or as we call CEFs. Senate Bill 2 instructed the Commission to promulgate regulations that provide for customers participating in a CEF to be credited on their electric bill according to the customer's subscription as a percentage of the generation of the CEF. In addition to Senate Bill 2, the regulations need to provide consumer protections for the customers of the CEFs, and those consumer protections must be developed in consultation with the Consumer Protection Unit of the Delaware Department of Justice.
And did Senate Bill 2 provide a deadline for the Commission's regulations?
Yes, Senate Bill 2 provided that the Commission must promulgate regulations by March 11th of 2022, unless it's extended by law.
Ms. Knotts, please summarize the proposed regulations.
The proposed regulations track the requirement of Senate Bill 2, and they add certain details around the certification process at the Commission. More specifically and consistent with Senate Bill 2, these proposed regulations increase the maximum size of the systems to 4 megawatts. They eliminated the requirement that all customers must be on the same distribution feeder. They eliminate the requirement that all customers have to be identified and signed up before the system can be built. They set forth the requirements for certification as a community energy facility, provide compensation to the CEF owners for 10% or less of unsubscribed energy, and require each CEF owner to certify that it serves at least 15% low-income customers,
and provide for the regulations of these systems by the Public Service Commission.
Please summarize the Commission's certification process under the proposed regulations.
The regulations set up a two-step process for a developer owner of the generating facility to become certified as a CEF. First, the applicant must obtain a preliminary certificate to operate, which establishes project viability. And to qualify for a preliminary certificate to operate, the applicant must offer proof of site control and provide that it has a completed interconnection study or a signed interconnection agreement from Delmarva. To obtain a final certificate to operate, the applicant must provide details around its financial, managerial, and operational ability to adequately serve its subscribers as the CEF. At this stage, the applicant provides the background. At this stage, the applicant provides the background and experience of its operating team, and it provides the required bonding as well as the form of contract and contract summaries it will be using for residential subscribers.
And why does the regulation utilize a two-step process for certification?
The two-step process was developed because the solar developers who participated in this proceeding advised staff that in order to obtain project financing, they needed certification from the commission that establishes project viability. However, at that time that they need to secure financing, they may not have determined yet who would be operating the facility, and they could not demonstrate at that time managerial and operational capabilities, nor could they provide the contractor or the contract summaries for residential subscribers. For these reasons, staff developed a two-step process.
And did staff include stakeholders in the development of the proposed regulation?
Yes, even before Senate bill was signed into law, staff drafted the regulations and circulated them to the stakeholders that participated in the drafting of Senate Bill 2. These stakeholders included the Consumer Protection Unit of the Department of Justice, the Delaware Division of the Public Advocate, Delmarva Power, DENREC, Sierra Club, the Delaware Solar Energy Coalition, the Caesar Rodney Institute, DMAC, the Delaware Electric Cooperative, the Delaware Sustainable Energy Utility, and the Coalition for Community Solar Access. After reviewing the feedback from the stakeholders, staff revised its draft, which is presented to the commission at its September 15th meeting. And on that day, via order number 9883, the commission accepted the proposed draft regulations and directed staff to publish on October 1st in the Register of Regulations. Based on the notice, staff received comments from 12 different organizations or individuals by November 1st. And based on those comments, staff made several clarifying revisions to the proposed regulations as well as certain other process changes. These changes were provided to the commissioners in red line form as well as a final clean version. These documents were also linked to the commission agenda for today's meeting.
Was there a public notice of this proceeding published?
Yes, staff provided notice of this rulemaking to the stakeholders who participated in the drafting of Senate Bill 2. We also published notice on the October 1st edition of the Register of Regulations, and notice was published on October 1st in the Delaware State News and the News Journal. And of course, notice of this hearing was published on the state calendar and the agenda for today's meeting.
In your opinion, are the proposed regulations in the public interest?
Yes, the proposed regulations track the requirement from Senate Bill 2, and in doing so, remove certain barriers to the development of community energy facilities in Delaware. And as you're aware, community energy facilities provide opportunities for Delmarva customers who can't participate in distributed solar rooftop, and they provide an avenue for them to participate as a CEF subscriber. Staff's engaged in extensive stakeholder process to develop the proposed regulation and believes that the adoption of the proposed regulation as final is in the public interest.
Does this conclude your testimony in this proceeding?
Yes, it does.
Thank you. And at this time, Chair Winslow, staff requests that Your Honor move into the record of this proceeding the affidavits of publication of notice from the Delaware State News and the News Journal as Exhibit 1, the red line copy of the proposed regulation as Exhibit 2, and the clean copy of the proposed regulation as Exhibit 3.
Are there any objections? Hearing none, all of the exhibits are entered without objection.
Thank you. And after the commission hears public comment, staff would request an opportunity to respond to any existing objections to the proposed regulation. Thank you.
Thank you, Mr. O'Brien. Mr. Slater.
Just a point of clarification, do I get to ask questions of the member testifying, or should I proceed with my comments and not be able to ask questions?
I think that you asking questions would be helpful, so why don't we do it that way?
Thank you. So I just have a question. There's actually two. Isn't it true that it was never discussed recovering the CEF costs from ratepayers during any of the forum meetings?
This question was directed to whom?
Oh, I'm sorry, to Ms. Knotts.
I'm sorry, could you please repeat that again?
So during the forums, would you agree that it was never discussed, the recovering of CEF costs from ratepayers?
You know, I'm going to object to that question. We just need clarification on what forums Mr. Slater is referring to, what the time period was, whether he's referring to any CEF costs. Certainly, CEF costs were included in Senate Bill 2, but if we can get some clarification around that question, then I'm sure Ms. Knotts will be able to assist the commission.
Sure. There were quite literally more than a dozen of Senator Hansen's forums that staff participated in. So I would just like to see if it is Ms. Knotts' recollection that CEF cost, that the recovering of CEF costs would be from all ratepayers.
I do not remember that issue being directly addressed.
Thank you.
Are there any other questions, Mr. Slater? You want to proceed with your
No,
presentation?
I'll proceed with mine. Thank you very much. So, good afternoon, commissioners. This is a, it's interesting how this has begun, but first, I do want to acknowledge staff's hard work on getting the regulations out in record time. They really did fantastic work to get these regulations done. In fact, before the bill was even signed, I think the regulations were out. And I know that wasn't easy, and so I do want to commend them because I know how much time it took. As for our comments, I'm sure you've read them, so I won't regurgitate all of them here. I note that in the last draft that was published with the agenda, which is the red line that Mr. O'Brien had mentioned, staff has accepted several of our more minor changes that the DPA proposed, and we appreciate that. As you may be aware, we had robust discussion and dialogue with many of the commenters who you'll hear from today, who joined us as participants in Senator Hansen's community solar forums. Many groups were involved in and commented on the draft legislation to find common ground, and that common ground involved certain levels of compromise by all parties. It was quite impressive that at the end of the day, legislation was drafted that everyone in the forum supported and passed the General Assembly with one no vote, which is really impressive. But I want to focus your attention on the one proposed regulation that above all else we believe must be changed. And that regulation is 16.10.4. And I begin with the relevant statute. The statute, which we all know is superior to any regulation, states in section 1014F6, the community-owned energy generating facility shall be responsible for any additional costs incurred by the electric distribution company, including billing-related costs associated with community-owned energy generating facility customers. The intent of the statute is clear. However, Regulation 16.10.4 ignores the General Assembly's intent. It will allow Delmarva to, and I quote, recover the credited supply and distribution costs provided to subscribers and the community energy facility in accordance with its tariff, end quote. No such tariff exists today, and the statute does not say anything about Delmarva filing a tariff to recover any costs from non-CEF customers. Contrast the General Assembly's silence on recovering any costs from non-CEF customers to what it did for Bloom. With respect to Bloom, the General Assembly specifically instructed the Commission to approve a tariff providing for a non-bypassable charge to recover Bloom's costs from all ratepayers. But here, the General Assembly did not instruct the Commission to approve a tariff for Delmarva requiring non-CEF subscribing customers to subsidize CEF subscribers. Instead, it said that the CEFs will be responsible for, and I quote, any additional costs, end quote, no exceptions. Not only did the statutory language not provide for recovery of CEF costs from non-CEF ratepayers, but at no time during any of the community solar forums or calls during which this legislation was being crafted, which everyone supported, was this issue raised, as you heard earlier. Senator Hansen convened the forum to address everyone's issues and concerns around community solar and seek common ground, and she should be commended for that. But not once did Delmarva mention a quote, distribution rate rider, end quote, on any ratepayer, let alone all of its ratepayers, to pay for anticipated losses, which weren't mentioned and aren't in existence today, due to CEFs. Had the topic been raised, this matter would have been vetted in the proper forum and brought to the attention of the General Assembly for the needed remedy. Proposed Regulation 16.10.4 and Delmarva's comments are inconsistent with the clear statutory text and is a backdoor way to obtain something that it failed to raise or didn't want to raise during the legislative drafting process of which Delmarva was a significant participant. The statutory language unambiguously places the responsibility for any additional costs that Delmarva incurs squarely on the CEF and its subscribers. Now, staff in Delmarva seem to argue that the only costs that the CEFs are responsible for are billing costs, and they point to the including clause in section 1014F6. Under Delaware law, the use of the word includes or including in a statute means that the listing is that, and I quote, the listing is in the statute is exemplary, not exclusive. This is a City of Dover decision that we cited in our comments. In another decision, the court determined, and I quote, as a matter of statutory construct, the words shall include are properly interpreted to indicate that the term structure encompasses items not expressly enumerated in the statute. This is the Wozner decision, which we also cited in our comments. Further, the legislative drafting manual is abundantly clear that the term includes is not limiting. Further, the General Assembly did not intend to limit recovery of CEF costs to only billing-related costs, and it certainly did not intend to require Delmarva customers that do not participate in the CEF to subsidize CEF participants for CEF-related costs. And how do I know this? Because I was there, and there was a significant amount of give and take. And I'll give you two quick examples. One was whether you should be paid excess generation, whether the CEF should be paid excess generation. And the other was whether or not the SREC should flow to Delmarva at no cost. Both of those issues, were raised and discussed, and that was part of the decision in the legislation because, again, all additional costs were going to be paid for by CEFs and the subscribers. But under proposed regulation 16.10.4 and Delmarva's position, and I state Delmarva because it's in their comments, ratepayers would pay at least twice for CEF subscribers' distribution rates and for the SRECs that Delmarva will purchase from the CEFs. If the Commission approves a proposed regulation 16.10.4, it will be going beyond what the statute authorizes it to do in determining who pays for any additional cost that Delmarva incurs. The legislature placed that burden squarely on the CEFs, not all of Delmarva's other ratepayers. Proposed Regulation 16.10.4 must be rejected and removed from the final regulations that the Commission approves. Otherwise, the Commission runs the risk of this regulation docket turning into another docket, to which I will not name, but we are all very familiar and lasted for 6+ years. Finally, Delmarva's comments in its red line of proposed regulation 16.3.3.4 that appears in the draft attached to today's agenda removes specific statutory language. The language removed states, and I quote, whose gross annual income by family size is at or below 200% of the federal poverty guidelines, or 60% of the state median household income published by the United States Census Bureau, whichever is greater. This comes directly from Section 1014 F16E. This red line change to remove statutory language should also be rejected. The statute is superior, and regulations cannot vest the Commission with more power than the statute gives it, or remove power from the statute that the statute gives the Commission. The language should be reinserted into that regulation. And lastly, regarding the deadline of March 11th of 2022, I simply point out that that is 114 days from today, clearly enough time to change the regulations and republish them. Thank you for the opportunity to provide these comments.
Thank you, Mr. Slater. Mr. Noyes, are you here on behalf of your department to make any testimony today?
Yes. Thank you, Chair Winslow and Commissioners. I just want to speak very briefly. DNREC does not have any substantive changes to propose or support to the current regulations. And the reason is, has already been stated, the extensive stakeholder work that was done, to which I would add, even before early in the year, the 3 state agencies here at the table, staff, DPA, and DNREC, we put our heads together and talked about what the essential features of a community solar bill should be. And those features found their way into the bill, and the bill was built around them. And for that reason, we were able to support the final bill, and as the regulation reflects the bill itself, we are supporting this. As for Mr. Slater's objections, our view is we have not taken a view on these. We have utility regulatory experts at the table, and we have not taken an opinion on the interpretation of the issues Mr. Slater has put on the table. But I just want to commend our colleagues in the other state agencies for a productive effort this year.
Does your department have any opinion on the effect that Mr. Slater's suggestions for changes will have upon the solar industry?
We have not come to an opinion on that.
Thank you. Thank you very much, Mr. Noyes. We have a list of people who wish to make comment. They're not, as far as I know, they're not technically parties to the action, but I guess they certainly are stakeholders, and we do have a public comment session, so we want to hear from all of the people who are on our list. There is one gentleman who has developed a conflict and wasn't able to be here. His primary message is that this is Mr. James Feinstein. His main comment is about the exceptional job done by staff and all the stakeholders in getting this matter together for us today's date. So we appreciate that comment in his absence. And we have, I guess, Dawn Kurtz-Crompton. You want to come up and please inform us as to your thoughts on this matter? I would appreciate it if the people who do come up subsequently, if you do have an opinion with respect to Mr. Slater's proposal, if you'd kindly express it.
Thank you, Chair Winslow and Commissioners. Dawn Kurtz-Crompton on behalf of Delmarva Power and Light Company. Delmarva did submit comments, written comments on November 1, 2021 via Delafile, and we proposed language to various sections of the draft regulations and also proposed a handful of new sections. We did review the red line that was embedded in today's agenda, and would like to thank staff, particularly Bill O'Brien, Pam Knotts, and Dimitar Kojikarov for their patience and diligence with this process. As stated by some of the other commenters today, this really was a Herculean effort, and we give a lot of gratitude to staff for all of their work. Other than the sole request that I will get into here shortly concerning a revisitation of the regulations, we fully support the red line draft regulations. As set forth in our comments on page 10, Delmarva would like section 16 to include a prospective commission review requirement of the regulations. Community solar is new to all of us here in Delaware, and in order to mitigate or ameliorate complications with real-world application of the regulations, which may emerge over time with changing technology, as well as address any forthcoming legislative changes, particularly with respect to net energy metering, which is currently under discussion within Senator Hansen's energy forums. Delmarva thinks it would be most prudent to require commission review of these community solar regulations to enable the process of revisitation of these regs as needed. As such, Delmarva Power proposes an addition as follows to section 16.11.7, which is entitled Periodic Commission Review. And we would propose, quote, "The commission shall periodically review the impact of community solar rules and recommend changes or adjustments necessary for the economic health of utilities, the continued reliability of the electric grid, and the interests of electric distribution customers." If the commission would like for us to address any other sections of our comments, we would be happy to do so, particularly with respect to 16.10.4. The inclusion that Delmarva has just mentioned would mitigate some of the concerns raised by the Delaware Public Advocate with respect to unintended impacts on customers. I do have with me here two colleagues. I have Steve Sunderhoff, who is the Manager of Strategic Programs for Utility of the Future, and I also have Ms. Sue DeVito, who is the Director of Pricing and Regulatory Services for Delmarva, should the commission have any detailed questions with respect to any of the topics we've discussed here today. We also would respectfully request that we would have some time to address any concerns or comments that implicate directly Delmarva's systems or processes hereafter. But I would like to reiterate that other than the inclusion of the 16.11.7, which we view as a non-substantive change, we do fully support staff's redlined regulations that were embedded in today's agenda.
Thank you very much.
Mr. Chair, this is Commissioner Gray. Can you hear me?
Yes, sir, I can hear you.
Mr. Chairman, I'm not sure who is speaking for Delmarva, but I do have a question for them. Is now appropriate, or would you prefer that I wait?
I think now would be a good time.
Okay, thank you so much. So my question in looking at 16.3.3.4, and by the way, this is a Herculean job. I completely agree. But if this language is stricken, which I think the public advocate indicates is statutory language, then my question is, how and where will low income otherwise be defined in the regulations? Because this is a definition of low income. Can Delmarva address that for me, please?
Yes, Commissioner Gray, this is Dawn Kurtz-Crompton. It's my understanding that that section is duplicative. Section 16.3.3.4 is cited elsewhere in the regs. Just give me a moment and I can try and dig this out for you. And part of the reason that we had proposed that it be stricken there was because it was elsewhere in the regs. So just one moment and I will answer your question directly.
Staff can assist anytime you would like.
If you have your finger on it, why don't you answer the question?
It's in the definition of low-income customer. And since that's a defined term in 16.3.3.4, it was duplicative to repeat the definition of low-income customer there. You just need to go to the proposed definition, which has the exact same language.
And what page is that on?
Thank you.
Page 5.
Page 5.
I think if that's Mr. O'Brien asserting that the definition is otherwise posted to the regulations, that responds to my question, Mr. Chair. Thank you. No further question.
Okay, does anybody else have any questions of Ms. Gertz-Crompton? No? We have next Laurel Pacera from CCSA.
Hi, I'm on the phone. Can you hear me?
I certainly can, thank you.
Okay, great.
Please spell your name for the record.
Thank you very much for having me. And again, I'll second that. Pam Knotts and the other staff have done a Herculean effort. This has been a real success of stakeholder engagement, and we really appreciate you and all your efforts. My name is Laurel Pacera, and I'm the Policy Director for the Coalition for Community Solar Access. We are a national coalition of businesses and nonprofits working to expand customer choice and access to solar for all through community solar. CCSA submitted joint comments with the Delaware Solar Energy Coalition and the Delaware chapter of the Sierra Club. And I believe Salar Naini from Turning Point Energy, one of our member companies, is also on the line today, and he has been participating in stakeholder forums as well. And I welcome his input after my comments if he wishes to speak. Community solar is playing an increasingly important role in providing equitable access to renewable energy. Today, most Americans do not have access to solar either because they rent, cannot afford to install solar panels, or otherwise don't have a roof that can support solar. Community solar provides everyone access to solar energy without the need to install a system on site. Again, we appreciate the hard work of Commission staff and all stakeholders to have achieved a draft of regulations that seem largely agreeable on most issues. And we also agree with most of what is included in staff's updated draft, with a few minor points that I will cover today. Over the past few years, we have observed in market after market that it is very important to ensure a disciplined approach for community solar projects that requires a high bar for entry. This will ensure an efficient market in which the more advanced projects proceed quickly and are not held up by projects that are less advanced or which may get tied up with permitting or other hurdles. Regarding the application process in section 16.2.3.1, the joint parties recommended that community energy facilities be required to post a performance security deposit. We realize this is an additional step to what staff has outlined in the process, but we think it can be accomplished by a relatively simple process. In our comments, we suggested this be accomplished during the application process with the PSC accepting the security deposit. I would just want to propose a simpler process, perhaps, and we have not discussed this with DPL, so this is sort of off the cuff a little bit, but what we typically do in other markets is we provide that deposit to the utility, who has a lot of experience receiving security deposits for different types of programs. So we would propose that DPL could accept the security deposit within 10 days of a CEF receiving a preliminary certificate to operate. And we have proposed a $25 per kilowatt deposit for all projects over 50 kilowatts. This would essentially amount to $100,000 for a 4-megawatt project, and our experience would help to better manage a program with a lot of developer interest by ensuring that projects which apply into the program are past most of the significant hurdles that can cause a project to fail. In our experience, it's much easier to add these types of requirements up front as opposed to trying to change the program after the fact. The second The second thing I'd like to mention today is regarding the process outlined in the updated draft related to DPL's requirements for cost recovery needed to facilitate billing services. We recognize the challenging nature of this issue, and we've had many discussions with staff and other stakeholders about it, but we feel that staff has landed in a good compromise solution in their updated draft. As we noted in our comments, we just need to stress that the project development requires these types of costs to be knowable and reasonable well in advance of project development. If costs are indefinite, it makes project financing much riskier and is likely to negatively impact the value that subscribers receive. Just on a separate note related to this issue and related to the DPA's arguments, we just wanted to note our strong disagreement with the public advocate's position with respect to cost recovery. DPA's argument that Section 16.10.4 should be amended to require community-owned generating facilities to pay DPL for all of the bill credit would completely undermine the program. To be clear, the main reason stakeholders approached the General Assembly to amend the existing statute in the first place was to update the bill credit value from being a generation-only rate to a generation and delivery rate. This retail rate bill credit reflects direct offsets from wholesale energy purchases that DPL would normally have to make and savings for distribution services due to the benefits provided by the community solar project. Importantly, the costs incurred by community solar developers are not just the cost of developing, owning, and operating the generating facility, but also subscription marketing, subscriber enrollment, billing, and customer service. DPA's proposal to charge CEFs the value of the bill credit would not only ensure that no projects are built, but would also undermine the intent of the General Assembly's effort to update the statute in its entirety. There's two other minor things that I will note. Regarding the questions required for third-party verification, under the definition section, we do not believe all of the questions for retail suppliers are appropriate questions for community solar because they're very different products by nature. So those questions including first month's pricing, futures pricing, switching, contract renewal. I'm sorry. Yes, absolutely. Sorry. Absolutely. So regarding third-party verification and the definitions, we just wanted to note that the questions that are related to retail supply products are not appropriate for those community solar products. In particular, questions around switching, contract renewal, and future pricing, those kind of things are not appropriate for community solar, and we think that those may confuse customers. So I think it would take some minor changes to write the appropriate questions for community solar, and we're happy to suggest those changes. But generally, we found that because community solar entails a savings to the customer, we found that third-party verification is not necessary. But again, happy to talk about some changes to those third-party verification questions. And the last thing I'll note is regarding CEF's ability to update subscriber allocation lists. In the draft regulations, this is section 16.6.10, just states that a written request is somewhat vague and could be interpreted to mean a request in the form of a formal letter. This is a very minor point, and we imagine that DPL will most likely use the same subscriber portal as the other PHI utilities, which would preclude the need for a written request. But because subscriber lists change somewhat often, we would want to ensure it is an efficient process. So we recommend ensuring communication is done in a standardized electronic format. And I'm sorry if I went too fast, I apologize, but I'm happy to answer any additional questions that you may have about the comments or recommendations to ensure the successful rollout of the program. And would just like to note that our members are very excited to see community solar come to fruition in the state of Delaware. And there's a lot of excitement to invest in the state. And with that, I'll see if Salar has anything to add before I pass it back.
Ms. Passera, is your name spelled Laurelpassera?
That's correct.
Okay, thank you very much for your comments. It's appreciated. And your co-worker or your other gentleman's name, Mr. Solar Nani, are you out there, sir?
Yes, sir. Yes, sir, Mr. Commissioner. Thank you for the opportunity to speak today, and apologies for not being able to be in person. I look forward to engaging in person in proceedings to come. Just for context, I run business development for Turning Point Energy. We are a national developer of community and utility scale projects. I also serve on the board of CCSA and have been very active in the policy realm on this on SB2 specifically. For further context, back in 2018, I actually started engaging members of the General Assembly, and as Ms. Pam Knox earlier noted, there were a number of issues with the existing statute that the program, the existing community energy facility program, non-workable. The biggest barrier there was the fact that full economic benefit, customers can only receive the full economic benefit in the form of a bill credit that would be the supply and distribution rate if they were located on the same feeder, which as most folks can attest, it's very difficult to identify where a feeder goes, and so that virtually made it so that the max economic benefit a customer could receive would be the generation only rate. And that was a specific issue that we've had a lot of discussion on. And if you read through SB2, that is clearly defined in the statute. And I did participate in the forums, which Ms. Knotts and Mr. Slater also participated in. And we spent, and specifically with Mr. Slater, we spent countless amount of hours talking about the value of the bill credit. We went back and forth several times, and I know that we ended up in a place where a lot of the riders were removed from the value of the bill credit. I guess the only thing I just want to make crystal clear is, just taking a step back, the existing program, if we did nothing with SB2, customers would be able to receive, there's the other barriers still, sure, but customers still would be able to receive the full generation credit. The intent all along was to, that which is non-financeable, the intent all along was to include something more similar to the retail rate, which we ended up with the generation and delivery credit. If we were to adopt Mr. Slater's suggestion, just at a high level, if the value of the rate is about, call it 10.5 cents roughly, and we charge CEFs for that same value, 10.5 cents, 10.5 minus 10.5 equals 0. So no projects would be built, and I just want to reiterate the importance of that. I find it hard to believe that the General Assembly and all the stakeholders would spend such a considerable amount of time in trying to revise the bill credit rate only to end up in a worse place than we were prior to SB2 being signed into law. The only other, the other thing I just wanted to reiterate in the comments made by Laurel earlier was the fact that SB2 does contemplate the rate recovery, the fact that any generation aspect of the bill credit be used to offset wholesale purchases. I think that's an important distinction because it's not as if there isn't any value that is being that there's not value that's being extrapolated from that benefit of those projects. Separately, the distribution value that these projects bring to the grid, which is what they're being compensated. The language that Mr. Slater is referring to, the intent all along in all the discussions we had was to account for billing related costs and other types of administrative types of costs associated, not the bill credit value. And so I think that was something that we went back and forth on DPL on, and I think most other stakeholders were on the same page as it relates to that. There were some disagreements as to how those costs should be, how DPL could charge those costs, and from the developer perspective, ensuring that there are checks and balances so that it's not just, it's not just any cost, but that we at least have the opportunity to participate. So I just wanted to point that out because that is, I believe that is everybody, a lot of the states seem to be on the same page related to that issue. But with that, I just wanted to thank everybody again. Thank you for the time today and the opportunity to allow me to speak.
Thank you, Mr. Nani. That's, I'm not sure if Gloria needs to have the spelling, but your name is spelled Salarnani, I believe.
You got it. One easy way to remember, one letter different than the word solar. So yes, you got it correctly.
Very good. Thank you so much, sir. We now have Mr. Vincent Marchella from ECA Solar, who's present in the room.
Good afternoon, Commissioners.
Good afternoon.
So my name is Vincent Moschella. I'm with ECA Solar. Our principal place of business is 282 Moody Street, Suite 202, Waltham, Massachusetts. I'd like to start by thanking the Commission for all the effort put in thus far, along with Senator Hansen and the stakeholders. I know that we began joining those calls and working with Senator Hansen in early 2021, and I would agree that a lot of work has been done between now and then. So since then, it seems that the spirit of this program, in our opinion, should remain focused on the inclusion of the LMI community. It seems like from the beginning, that was one of the predominant focuses, other than removing barriers to entry for solar. It is, after all, a mandatory requirement that at least 15% of the output generated be assigned to LMI customers. We did find a couple of stipulations in this bill that we felt would drastically reduce access to those customers, and that was really the focus of our comments. And then beyond that, just promoting competition and a diversified energy supply mix in the state of Delaware. So I would like to start by disagreeing a little bit with a point that was made earlier regarding the definition of low-income customer. I do think that the definition that is found on page 5 is inadequate, and it is better defined, and I don't know if it was moved around in the red line copy. I wasn't able to sort of cross-reference against our comments, but I know at the time that our comments were made on November 1st, low-income customer was pretty well defined in 16.4.2.3. So our first comment is that the low-income customer definition should just read a customer who meets the criteria outlined in section 16.4.2.3. It is quite a complex definition, and I don't think that complexity belongs in the defined terms section. We would also recommend the addition of the following definitions, master metered facility being one of them. As many people in this room and on the phone might already know, if you've served the low-income community in the past, they often reside in master metered buildings, whether those buildings be owned and operated by the state, municipality, or a private individual. It is common practice that they be master metered, and we feel that definition warrants inclusion. Another one be the definition of a public entity. And so that brings us down to what we believe was a section 16.6.2 that we feel restricted access to the low-income community, and that was that no single customer might participate in more than 4 community energy facilities. In doing so, what you risk is these large low-income housing buildings, master metered facilities, if they're only allowed to participate in 4, and there's limitations per project in which they're able to consume from. We have specific instances where only 40% of that building or property could actually be subscribed into the program, leaving 60% of, the LMI stakeholders there cut out of the program. In doing so, you're actually limiting the amount of solar that can be built in the state by keeping this in the rules, because there is the mandate to maintain 15% LMI. So if you have situations where 60% of the customers are effectively cut out of the program, and you are reducing the amount of LMI customers that can participate in the program, by default, you are reducing the amount of solar that can be built in the state. It's already going to be hard enough to maintain those subscriptions. I don't think we should make it harder. And I certainly don't think that we should, cut anyone out of this in a program that was, effectively built to support them. So yeah, ECA Solar respectfully requests that the PSC consider the negative impacts that the structure proposed by this section of the draft regulation would have on customers and market stability. It's important to note that the PSC's restrictions may inadvertently result in limiting the ability of certain customers to fully participate. In order to create a competitive retail electric supply market, it is critical that the project participation cap not apply to low-income or master metered facilities. With that, I'll conclude actually, I would also like to mention, as a solar developer, I very rarely disagree with CCSA. I strongly feel that they do a lot for our industry, but I don't believe that the inclusion of a $100,000 bond per project does anything except for add administrative burden to the state and anyone that has to operate this program. The program does not have a firm cap on it. Therefore, there's really no harm in issuing these certificates of eligibility. And I don't think that the state sort of managing all of these deposits would be worth the effort. And speaking as a developer that I feel could make those payments, I don't feel that they add anything. It's just unnecessary. With that, I'll open it up for questions.
Does anyone have any questions of Mr. Moschella?
Mr. Moschella, the section that you referenced, the 16.6.2,
Yeah.
You, correct me if I'm wrong, but you're objecting to the limit of, that a customer may subscribe to no more than 4?
Yes.
Isn't that out already? Hasn't that been removed from that section?
It was actually relocated and restated in its exact form, which to me seemed pretty deliberate.
Where's that section?
I don't have the red lines in front of me, but I do know that it was relocated.
Okay,
Yeah.
so that's why. Okay, thank you.
You're welcome.
Thank you.
That's it. Thank you, Mr. Moschella.
You're welcome.
Moschella. Next, we have Dustin Thompson from the Sierra Club. And I assume you're on the telephone? Are you on mute by chance? If you come back to us, let me know. Mr. Dale Davis, Delaware Solar Energy Coalition.
Hi. Yes, I am on the phone. This is Dustin Thompson. Sorry, I'm also listening on the live stream if I'm a little bit late.
Okay, you're up. Go ahead.
Can you hear me?
Yes, sir.
All right, great. Sorry about that. There's a bit of a delay, I think, between the phone and the live stream here. Yes, my name is Dustin Thompson. I am a staff member at the Sierra Club Delaware chapter. Sorry I was not able to attend in person. Would like to start out just by giving some background on the club. The Sierra Club Delaware chapter has been operating in the state for over 50 years, though I joined in 2019, and I work primarily on renewable energy policy and community outreach. So I'd like to just thank the staff for all their work on this and for the very open and inclusive process that they operated under in getting these drafts written. I do think that the regulations that's written can really bring equity to access to renewable energy in Delaware, which was a primary goal for the Sierra Club in working on community solar legislation here in Delaware. This bill, I think, helped bring balance, as do these regs, to many voices that came to the table to help solve this policy issue. Originally, this section of the code, I do want to speak to advocates' comments a little bit. The section of the code that was covered in Senate Bill 2 was actually originally housed in the same section as net metering. This is essentially a form of virtual net metering, community solar. And in fact, in other jurisdictions, community solar statutes explicitly call it virtual net metering. And I think one of the big goals of Senate Bill 2 was to bring into line net metering and community solar and to treat them essentially as the same, specifically in regard to the credits on participants' bills. As was already stated previously, individuals had to be on the same feeder in order to receive the full benefit that they would normally receive if they were able to actually install rooftop solar and net metering through our net metering program. And this was one of the main barriers to allowing community solar to thrive in Delaware, as it has in many other states in the U.S. Because of the give and take process that was already alluded to that brought this bill around, net metering with rooftop solar will now still be more beneficial in terms of bill credits. But what came about still offers profound benefits to community solar subscribers. Due to the suggestions by the stakeholders during the drafting process, the statute that's in SB 2 was moved to be separate, but under the same title of the code as net metering. Now, this has had kind of a few impacts that we are still having discussions around that may or may not need to be addressed in the future. But I believe the overall goal is to allow those participating in community solar to gain the same benefits or as close as possible to those who have the means and opportunity to install solar on their roof, specifically savings on their electric bills and the knowledge that they're helping reduce the impacts of climate change. We are in the midst of conversations around net metering now with Senator Hansen and the group that was working on community solar and is continuing to work on energy policy. And perhaps maybe we'll address some of the advocates' concerns in that process. However, it should be recognized, though, and this is a big part of the conversation we're having right now, that there are and that is why our net metering statute operates in the way it does, and why community solar should operate in the way that the draft regulations have outlined.
Mr. Thompson.
To do elsewise, yes.
You went blank there for 3-4 seconds, and we missed part of that last comment you made.
I apologize. I've been having a lot of trouble with my phone lately. Can you hear me now?
Yes, sir.
Okay. I'll just start at this particular comment at the beginning. So what I was trying to say was we are in the midst of conversations with Senator Hansen and the energy stakeholder group that worked on community solar and SB 2. We're having conversations around net metering right now, and perhaps we may be able to address any necessary concerns that are being brought up in the advocates' comments during that process, since there is such parity between community solar and net metering, which was the goal of SB 2. But it should be recognized that there are both grid and societal benefits from distributed generation and from community solar. And this is why the net metering statutes operates in the way that it does, and why community solar should operate in the way that is outlined in the draft regulations. To do elsewise would essentially reverse all the progress we have made thus far in the program and in renewable energy efforts in general. Now, on the matter of SRECs, I do not believe it was ever discussed that the goal was to essentially transfer the SRECs to Delmarva administratively. I know that's a conversation happening right now with a potential pre-buy program being discussed with the Renewable Energy Task Force around SRECs that came about through the Green Energy Fund. But the change with regard to SRECs and ownership of the SRECs during the discussions on SB2, which was a robust discussion, was for the SRECs ultimately to go to the CEF rather than the customer individually to help offer a greater bill savings to the customers. Now, the CEF can relinquish ownership of the SRECs to the customer through a contractual obligation, but essentially we flip the default. So instead of going to the customer, they would go to the CEF to help with financing and again, with bill savings. So I will be happy to answer any questions around my understanding and interpretation of the process thus far, but we sincerely appreciate the time to comment today. Apologies for the technical issues on my end, and we do hope that the Commission approves the draft regulations with no significant alterations. Thank you.
Thank you, Mr. Thompson. Does anybody have any questions of Mr. Thompson?
I would, Mr. Chair. Just to clarify on the SRECs would go to the CEF. However, there is no requirement in the statute or in the regulations that they take the SRECs and that they benefit the customer in any way. In fact, there's actually nothing in the statute or regulations that says that a customer of a CEF that they won't see a higher bill. I mean, that could happen, as in other states where they've guaranteed some sort of bill savings. So I just wanted to clarify that comment.
I think that what Mr. Thompson meant was that the parties can contract and deal with those SRECs amongst themselves. There's no provision in the regulations or the rules or the statute that says that they can't.
If afforded the opportunity later after all the other comments, I think I have a path forward, but perhaps we should hear from everybody else first, if that's okay.
Certainly. Mr. Davis, your turn, sir.
Hello, this is Dale Davis from the Delaware Solar Energy Coalition. I'd like to start out by thanking everyone who's worked so hard to get this bill across the legislature and then get the regulations in the form that they are to get them before the commission. I will say that there has been much back and forth on these regulations to get them to a point where we think we've got a workable program. I think everyone's aware that community solar has actually been available in Delaware since about 2010, but has never been viable due to problems with how billing would be handled, the remunerations, et cetera. And this bill and this set of regulations has gone very far in fixing all those problems to where we think we're going to have a very robust community solar program now. I'm a little concerned that we're suggesting some last-minute changes after all the work's been done. I think that while some of those changes might be worth consideration, I don't know that at this point that they should be drawn into the bill at this time. But I would certainly defer that to the Commission's expertise, set mine. So I don't have a lot of comments on this other than it's been a long time getting to community solar in Delaware, and I think we're finally going to be there and have a viable program with a lot of LMI participation. So I'm hoping that the Commission sees their way forward to approving these regulations and we can get moving on these jobs. That's really all I have to say.
Thank you, Mr. Davis. Mr. Ed Jackson, please. Mr. Jackson is from Affinity Energy Management.
Yes, hi. Can you hear me okay? This is Ed Jackson. I've dialed in.
Yes, sir.
Just want to thank the commission staff and the commissioners for the attention to this very important program. I really don't have any additional comments than what was submitted in writing, and it appears, based on review of the draft, the revised draft online, that my comments were taken into account in that. So I appreciate the opportunity to participate and plan to continue to participate.
Thank you, Mr. Jackson. Mr. Nichols, you want to come up front and have a seat and give us your opinions?
My absence during the negotiations and the drafting of the bill was due to my wife's ill health. She almost died. She's stable now. I tried to stay as involved as I could, so I apologize for my late entry. I wasn't going to mention this, but since the Sierra Club representative did, let me note that if you choose to, you may go to Our World in Data, which is a site maintained by Oxford University, and you can look at carbon dioxide emissions by region globally. And you'll note that if the U.S. emissions went to zero, global emissions would still continue to rise. And that's because of what's transpiring in China and Asia, India, Asia writ large. Our efforts to reduce carbon dioxide in the name of fighting carbon pollution, global warming are meaningless. And it's verifiable if anyone chooses to do it. I didn't want to mention it, but I will. 10 years ago, I appeared before the commission to speak about the predicted failure of Bloom Energy. Two of the commissioners were serving at that time. I was right. Bloom Energy is an abysmal failure. They've lost $3.2 billion. They never hit their 900 job hiring goal, and recently, and I'll introduce this as part of the public record, they had to
Mr. Nichols, I apologize for interrupting.
I'm finished with that comment. $9.4 million. I just wanted to make a point that my predictions turn out to be accurate. That's my point. My primary reason for being here is to read into the record my public comments. So if you'll indulge me, I'll do so now. Community-based solar is distributed generation. Thus, it reduces the amount of electricity delivered by the regulated utility Delmarva Power. Yes, I will. Thank you. Community-based solar is distributed generation. Thus, it reduces the amount of electricity delivered by the regulated utility Delmarva Power to their customers. The delivery of less electricity because of volumetric pricing means new rate cases to determine delivery charges required to maintain infrastructure. Because Delmarva Power supports renewable energy, the supposed regulations should require the regulated utility bear all costs for rate cases attributed to revenue losses due to distributed generation as a measure of their support for community-based solar. The Commission should also direct Delmarva Power to study, at company expense, the expected loss of revenue before the adoption of new community-based solar regulations. The analysis should project the anticipated delivery charge increase based on the current 10% solar renewable energy portfolio standard mandate by 2035 and an expected 20% solar mandate by the same date. I've been in attendance at early meetings. There are people who would like to get 100% of our electricity from unreliable sources. It's an impossibility. Part of me wants to just sit back and let it happen, but I have to say I did something, so here I am. Their analysis should model static and declining use of electricity by schedule compliance year. Ratepayers without access to community-based solar will see their delivery charges skyrocket as distributed generation increases. This is behind-the-meter generation. It's just rooftop solar writ large. The Commission's duty is to protect the other ratepayers from the results of ill-conceived public policies before designing new regulations. That was one of my comments. The second comment has to do with environmental regulations and should be reflected in bonding. The proposed community-based solar regulations fail to address significant environmental problems associated with such deployments. Common sense measures proposed to protect the safety and well-being of not only Delmarva Power ratepayers, but also community at large should be considered. I note proposed measures. A regulation to require independent environmental assessment to determine adverse effects on flora and fauna due to large-scale solar deployments. A regulation to require independently verified material safety data sheets for solar raw materials, intermediate materials, and the final product. A regulation that identifies solar panels as hazardous waste and requires manifest to track them from cradle to grave with disposal at an EPA-registered hazmat treatment facility or an EPA-registered recycling center. That concludes my comments. If you'd like to hear any more of my opinions, I'd be happy to share them with you.
Mr. Nichols, thank you very much. I have to confess that I think that you probably do have a high percentage of being correct, but you're not perfect. The only person I know that's perfect in their opinion is my wife. Thank you for your comments.
Thank you, sir.
We have, I think, next is Ann Kirby.
Hello, this is Ann. Are you able to hear me?
Yes, ma'am.
Okay, thank you. I am representing Green Building United. I am a council member of the Delaware community for them. I also am the private sector co-chair with the Delaware Energy Services Coalition. I work in the solar industry, and I'm also a Delmarva Power and Light customer. And one thing I was not privy to the red line document, so what I'm not sure of is whether or not my written comments are reflected in the red line copy. So I don't know if I need to review those today or not. They were regarding the definition of co-location and whether or not that there needed to be clarity of non-community and community solar projects being able to be co-located. Also regarding a subscriber's right to increase their subscription base based on an increase in their electricity usage without having to wait for a 12-month history.
Mr. O'Brien, can you help
And
Ms. Kirby on those couple of issues? Or Ms. Knotts?
Chair Winslow, we did clarify the definition of co-location in the red line version because we had already had a defined term of affiliated interest. So we went to the defined term rather than submit a completely new definition of affiliation within the definition of co-location. It shortened the definition significantly. I'm not sure if it met all of Ms. Kirby's comments.
Well, what I was really getting at that it wasn't addressing the possibility of there being a non-community solar project co-located, and it seemed like it was ambiguous and that it might be able to point to that a community solar and a non-community solar project would not be able to be co-located.
Yes, Ms. Kirby, Ms. Knotts just reminded me that we actually did incorporate your suggestion by limiting co-location to just community energy facilities.
Okay, that's fine then, thank you. And then the other thing was a subscriber's right to increase their subscription based upon an increase in their electricity usage. It seems the way it was written that they would potentially have to wait for 2 12-month periods of increased electricity usage before they could increase their subscription.
Bear with us for a second, Ms. Kirby.
Thank you.
Chair Winslow, I'd like to pass this off to Ms. Knotts. We did not make any changes based on that suggestion, but we do believe that you don't need to wait 2 12-month periods.
Oh, Ms. Kirby, this is Pam Knotts. If I could just see if we have clarified this, since this is based on 110% of the subscribers' usage, are you saying that if a subscriber used more, that 110% would not change?
Well, it was 16.6.1 said that it shall not exceed the average of 2 previous 12-month periods at time of subscription. And that to me read that if someone subscribes and then say, for example, purchase an electric vehicle, that they may be stuck, waiting a year and up to 2 years before they can actually increase their subscription level.
Yes, I mean, we'd have to determine that it was less than 110%. But as far as the waiting period, I mean, and most likely it would be historically based so that they could determine that 110%. And you're saying about an increase, we just took the 110%, that's how we looked at it, that it cannot exceed that 110%. And I'm
Okay,
not sure.
because 16.6.6 says that Delmarva may annually audit to ensure it does not exceed 110%, but 16.6.1 says that it shall not exceed the average of 2 previous 12-month periods at time of subscription.
Right, and our intent was in 16.6.6. I'm sorry, what was the first one that you cited about Delmarva would reevaluate?
Well, 16.6.6 says Delmarva may audit annually to ensure it does not exceed 110%. So it sounds like maybe what you're saying is that as long as Delmarva has the right annually to audit, that as long as someone's not going to fail their audit, that they're going to be okay?
That's our intent.
Okay. All right, then. The other comments I had were in regards to the several LMI requirements that I wanted to assure that those requirements were not going to create an onerous situation, an unequal situation for the LMI subscribers, such as it read that there was a necessity for a photo ID, but it didn't read that anyone else had to provide a photo ID, that they had to provide a utility bill, but it was not required for other subscribers.
Ms. Kirby, this is Pam Knotts again. We did look at the comments from quite a few of the commenters on that, and we did strike the requirement of a photo ID of the applicant, and we also struck at least 1 or more utility bills within the last year.
Okay. And then the other thing was, and again, I think that maybe this was just a clarity, and perhaps I suspect you've corrected this too, but just in 16.4.1.3, seemed to me that it just needed to be qualified that if the census tract condition was met, that there was no further documentation required beyond that. That it was one of those, any one of those requirements needed to be met.
Yes, that is correct, and we did make that a little bit more clear in 16.4.1.1. This is Pam Knotts again. I'm sorry.
That's okay. I recognize your voice.
Okay. And for others on the phone, so that. Or it does say or proof. So we did clarify that. And there is a new 16.4.1.3 that I think you just quoted. So that is a new red line, and that actually speaks now to master meter buildings.
Okay. And then the final comment was regarding 16.4.4, that an LMI subscriber was, that I had said that once they've been verified, that they should continuously meet the status as long as it's a continuous subscription, that they should not require ongoing verification, and that the certified energy facility shouldn't be penalized if that LMI subscriber elevated out of qualification during their participation.
This is Pam Knotts again. In 16.4.4, we did not do any edits, and because we feel that that is consistent with what Senate Bill 2 also stipulates.
Anything else, Ms. Kirby?
I just wanted to add comments upon hearing Mr. Slater's comments today. I just want to stress that as a solar developer, we strongly lean on CCSA and their expertise in these types of issues. And I believe that what Laurel Passera and Salar Naini and Dustin Thompson said, all of those things to me are consistent and clear, and particularly Dustin's correlation with the original intent being the same as net energy metering, that we need to keep that consistent. I can tell you that while I work in commercial and utility scale solar at this time, when I started my solar career, I worked in the residential and small commercial arenas, and I can tell you that I know that there are a lot of individuals and businesses that can very much benefit from this, and that I think that we need to move forward with getting this passed and not delay or make it onerous, or not onerous, but make it not able to move forward with these types of projects. Like everyone has said repeatedly, there's a lot of work that has gone into getting us here, and there was a lot of thought and a collaborative process, and so interjecting a whole new concept at this point just really doesn't make any sense. And thank you very much for allowing me to speak today and for considering the thoughts of everybody who talked today.
Thank you very much, Ms. Kirby, for your comments and thoughts. Is Mr. John Shields on the line? Is there anyone else on the line who wishes to speak who has not had the opportunity so far?
Yes, Mr. Chair, this is Ross Abbey with U.S. Solar.
Please spell your name for the record.
Of course. First name Ross, R-O-S-S. Last name Abbey, A-B-B-E-Y, with U.S. Solar.
Please proceed.
Thank you. It's my first time appearing as a stakeholder for the commission, and I apologize, I didn't know if I needed to put my name on a list, but thanks for hearing me out. U.S. Solar did submit written comments on November 1st in this docket, and we proposed a wide number of kind of practical clarifications to the draft code sections, many of which staff have already apparently adopted instead of redlined, so I appreciate that. Of course, appreciate all the hard work of the staff and other stakeholders through this long process. U.S. Solar, for background, is about a 35-person development shop. We do community-scale projects across the country. And I guess I'd just like to touch on 5 or 6 elements of our comments that have not yet been addressed, either in the red lines or in the hearing today.
Well, get to it.
In terms of sorry, I'll just proceed. In terms of the length of the program contract, we agree with CCSA that it would be very helpful to put a term of years on that. I believe this is a feature of community solar programs in every other state. It allows the developer to enter into.
We had another webinar, 2 to 3, that he was going to jump on.
Is that a question, or should I just continue?
I don't know who that was, and whoever interjected, would you be kind enough to wait till this gentleman finishes his speech or his thoughts and comments, and then we all have an opportunity to speak again.
Thank you. As I was saying, my understanding of the draft rules, there's currently no term of years for the program contract under which, the facility is paid by the utility, or excuse me, facilities subscribers are paid by the utility. A lot of other states have a 25-year term, which is very useful for contract formation because you have to enter into contracts with obviously the landowner, financiers, subscribers, warranty, O&M, and having a set and known term for the project contract helps facilitate finance and all those contracting pieces. I know CCSA and the Joint Commanders mentioned this term could be up to 35 years.
Could you slow down, please? Is this the court reporter? Could you
Yes.
slow down?
Oh, I apologize. Yes, I'll try. CCSA and the joint parties have proposed a program contract term of up to 35 years, which USOR would also support, and that's kind of the maximum length that some of these panels, solar panels, are warranted for. That's one item. Second item is, we're arguing for more due process in the rules as to the community energy facilities. A lot of states, they'll have provisions, as we've suggested in our comments, where the project can be penalized, can be potentially disconnected from the grid if it violates the rules, but only after the operator first receives fair notice of the alleged violation and also an opportunity to cure, reasonable opportunity to cure. So we think this could be inserted, for example, into section 16.11.5. Of course, this really helps when we turn to go get a financing for these projects, capital financing, because the financier wants to know that there's not potential for sudden default on the project. Of course, if the project were yanked off the grid, it would also harm all the existing subscribers. And so that's why we respectfully ask for a due process provision that allows us to cure any or contest any alleged violation before we're disconnected. A third piece goes to calculating the 110% subscription size capacity limit. I think similar to the previous speaker, we have some concerns that this could be overly binding on subscribers. What other states have done that we think works well is that 110% sizing test would only be done on 3 separate occasions. Once, when the subscriber initially signs up and it's uploaded into the program portal, and then later only if the customer moves to a new address or voluntarily attempts to resize their subscription. Related in section 16.61, it'd be really useful if there was an exception in there that allowed for, so this is a section that speaks to, the 2-year history to size. The problem we see is that sometimes, specifically with renters, they might not have 2 years of history at their current location. And so in that situation, there has to be some exception to allow for estimation of that. And I think staff did make a tweak to this section. I'm just not sure that it fully captures my concern. Sorry, was there any question?
I'm sorry, I thought you said there were 5 points. I only have 4 written down. Am I mistaken?
Yes, I wanted to also speak to 1 or 2 remaining points. On 16.6, so this is the section where we propose that the 110% test would be conducted, at the time the subscribers initially uploaded. The same provision in section 16.66 also says that the CEF can't charge subscribers more for the subscription than the bill credits delivered by the utility. If I'm understanding this correctly, under the new red line, that basically puts a price cap on what these CEFs can charge subscribers on a kilowatt-hour basis for the subscription itself. And I wonder if staff could comment on that question.
Ms. Knotts, is that a statutory provision?
sorry,
16.6.61, I believe, is what he's talking about.
yeah, I'm sorry, could you tell me again which one? Because I'm not sure that it was 16.6.6.1, but if you could clarify that, I would appreciate it. This is Pam Knotts.
Of course, yeah. Just a second here.
Would you restate your objection under 16.6.6.1 so Ms. Knotts can address it?
Yes, thank you. Well, there's just a question of how often that 110% test is conducted by the utility. Is it every day, every week, or as we're proposing, it would be only at set times? For example, when the description is first uploaded into the system.
This is Pam Knotts. I believe that 16.6.6.1 addresses that it says and historic annual use is calculated on the average of the two available at the time of the reassessment, and I believe that's annually.
Okay. Well, annual reassessment is, maybe that needs to be more explicit in the provision, but I think that's certainly preferable to, some sort of continual reassessment. And then 2 sections down, 16.6.6.3, this is the one I mentioned where it seems like this is placing a restriction on the actual pricing that the staff can agree to with subscribers. Sort of like a price control. Is that, I guess, the intended effect of this provision?
Well, this is based on the credits, correct?
Yes, and we have proposed in our red line that the developer or the operator shouldn't be able to charge for more kilowatt hours than the kilowatt hours that have been delivered to the subscriber. No fair is charging 100 units if only 50 units were delivered by the facility through the utility. But this doesn't speak to kilowatt hours, this speaks to more of the dollar, the pricing aspect of it.
Right, because Delmarva will monetize this, but if you go to the section that says about the calculation, in fact, I think it's in 16.9.1.1. It actually says how that monthly bill credit would be calculated. I'm not sure if that answers your question there. So it is kilowatt hour credit multiplied by the applicable rate.
Yes, that makes sense, but then 16.6.6.3 seems to limit the facility and what they can charge. Typically we would, if the expected bill credit is 10 cents, we would charge 9 cents. That's how we actually, obviously get subscribers to sign on by offering them a discount. But typically, a discount isn't mandated in the regulations, and in some markets, some situations, you are allowed to charge a premium. Of course, it has to be agreed to by a subscriber and has to be very, clear in the contract. But this seems to say we can't charge anything above the value of the bill credits that are delivered by Delmarva.
Well, Mr. Abbey, I mean, most of the conversations that we had with the industry said that there would basically be, one of the business models would be a guaranteed discount or a guaranteed discount from their bill. So, I mean, if this was equal, there would be no discount. But if it would be greater, then my understanding would be in that business model that the CEFs would actually be charging more than the subscribers would get in the bill credit, which I can't really envision that. And maybe you could clarify if that could actually occur, that subscription to a CEF would actually be greater than what the subscriber could benefit from. And perhaps I'm misunderstanding what you're saying.
No, I think you're probably, yeah. So, for example, in Colorado.
Mr. Abbey, state that again, please.
Yes. So the concern is that in certain instances, a developer might want to charge a premium, for example, to allow them to charge a lower cost to low income. Or you might have a case where the bill credit declines in the future due to no fault of the developer, but it declines below the price for the subscription. And we have seen that in other states like Colorado.
Okay, thank you for that comment. What's your next comment, please, sir?
Yes, I'll move on. Although one second thing on this provision, this also ties it to the monthly bill credits, and that can also be a concern sometimes when there's rollover. Under this provision, I think we'd have to wait until the subsequent month or many subsequent months to actually bill for that rollover credit, which is not typical. But I don't want to belabor that point. I do appreciate staff accepted a lot of our suggestions for making it easier to qualify low income. But there's a kind of a final structural piece I want to speak to that I don't think was addressed in the most recent red lines, which is right now, section 16334 ties the 15% low income requirement to number of subscribers. And I suppose it is possible to do it that way, although I think all other states actually tie that low income requirement to a percent of the project's capacity. So for example, in our red line, we proposed 15% of each facility's AC rated capacity be reserved for low income. That has a number of advantages. It makes it, I think, easier to administer and monitor. It makes it much easier for the operators to keep tabs of it. And then it also allows for the penalty for failure to satisfy that 15% requirement. The penalty can be unsubscribed energy. It gets a little bit complex, but this is what other states have done. You basically say, we're going to set aside 15% of the project capacity, and we, the utility, or the... Yes. So it makes a big difference for implementation on all parties, whether the 15% requirement is tied to number of low-income subscribers or percent of the project capacity that must be subscribed to low-income subscribers. The draft currently points to the former. We suggest the pointing to the latter is a lot easier all around for the reasons we go into in depth in our comments. If I could just give maybe one example, just to illustrate a little bit, and then I can close my comments. I apologize for the length. If you tie it to the number of subscribers, then if one of those low-income subscribers suddenly goes away, for example, if they want to leave the project under the subscription agreement, or they die or whatever, or one of our non-low-income subscribers suddenly leaves the project, all of a sudden that changes the numerator and the denominator for this percentage test. And the project can quickly fall out of compliance and be subject to penalties, which I think is drafted would harm all the current subscribers. It gets really messy and it's hard to administer and police, including on our side. But if you go with the 15% capacity requirement, that's much easier to monitor and police, and there's much less likelihood of inadvertent default. So I can just leave it at that unless there are any other questions.
Okay, thank you, Mr. Abbey.
Thank you.
Appreciate your input. And is there anyone else out there that wishes to speak on this matter that's on the telephone? Five-minute recess. Gloria, is that going to be long enough for you? 5 minutes?
See you behind.
How's the pain like?
Somebody like trying to get back at you.
make some contact.
Yeah. All right. Once I get that, you go ahead. Yeah, I guess I will.
Oh, yeah, I have those.
Oh, I heard that, yeah. Yeah. No, that's. Right. I didn't understand what you were saying. Right, no, that's good point, yeah. But I don't know, I don't think that I can do it. I'm not sure. I'm not. It was interesting, it wasn't particularly hard.
That only took a couple of
We probably searched for 7 or 8 minutes before Judge Traynor took his trainer. And then he started asking us questions that were really, pointless. It was like, well, why didn't you interview? Well, we wanted to live in Yeah, well, but, True. Well, no, basically.
The live stream is still on. I don't know what you're talking about. I just want to let you know that the audio can still be heard.
Right, and so that's why we.
Yeah. I left her a message and said, I'll be here. There's no way I could have done that.
I got a new hit. Oh. It's only 2 weeks old.
Go back to the room when you go
How does it feel?
It hurts.
I've gone from the water to the cane. Well, that's.
No, you didn't say anything.
Yeah.
You said it's bad enough.
And I know that the pain will subside, so. They offered me and I refused.
which means that the subscriber's losing money. Yes.
And I said, we didn't discuss that. Well, I mean, they still get credit payments, and I'll tell you, but they would get a bill from the CEO. I slept through pretty much the first 4 days. I mean, I had a timer, you know, I had my alarm clock on my table to wake me up so I could take the thing, and then I would fall right back to sleep. Well, the credit's good. I mean, kilowatt hour. That's what I'm saying. And I think that's what he's saying. Yes.
Oh, yeah, no. I agree with you. I agree with you. Yeah, I know. I was having a hard time with several of them, to be honest with you.
But since Delmarva's monetized everything, we put dollar value.
Okay, let's reconvene. That's crazy.
You're the only person that saw that.
Could we restart the meeting, please? I believe we've heard from all of the interested stakeholders, and we have a lot of stuff written down. I guess I'm open as far as the path forward is concerned, but I thought maybe I'd get some input from my commissioners. Commissioner Gray or Commissioner, let's go with Commissioner Gray to start off. Do you have any comments or suggestions about changes as a result of hearing all the comments, changes to the red line or the final document that the staff has prepared?
Mr. Chair, was that directed toward me?
Yes, sir.
All right, thank you, if you can hear me. So lots of comments, very good ones. I think that in large measure, my sense from listening is that staff have taken many of these comments to heart and infused them into the red line document. I did take quite a keen interest in the last presenter's thoughts about anchoring the LMI to capacity and not subscribers. I would anticipate that subscribers may fluctuate so rapidly, it may be somewhat difficult to keep up with and keep that calculation of 15% of prescribers, but the capacity is relatively stable. It may shift over time, but clearly not as rapidly as will subscribers. So I think that change I would strongly endorse. I do take to heart Mr. Nichols' concerns about whether or not the actual policies are going to impact the revenue line of the utility and or new rate cases and costs. So for the record, I would be also very interested to track that over time. But I think, on the other hand, there's quite a bit of merit to move these regs in place sooner rather than later, because I think there's an overall benefit. I don't yet know how to assess the concerns of the public advocate with respect to the costs for distribution and supply, because I don't know if that would be offset in some other way in which this is calculated and is socialized for all customers within Delmarva. So those would be my relevant comments based on what I've heard. A lot of attention and energy toward this. But before I yield back, Mr. Chair, I want to thank Senator Hansen. I know that I've seen lots of communications but not been engaged centrally to her process. But I appreciate her effort as well to rally all of the energy bringing this to our table. So I'll yield back now, Mr. Chair. Thank you.
Commissioner Gray, how do you feel about Delmarva's suggestion for periodic review in the language that they set forth?
In general, Mr. Chair, I am in favor of the proposal as presented, and I think usually our orders end with something that says we do have the right to come back and review.
I understand that, but I believe that what the intent of the mover on that probably is, it says that to make sure we do it. In other words, in all of our orders, we say that, but it's very rare for us to go back and make a change.
Mr. Chairman, sorry to interrupt. I think we lost the line, so we'll try to reconnect.
We lost Commissioner Gray?
Yes.
Yeah. Commissioner Gray?
Yes.
We didn't pay our bills. We didn't pay our bills.
To the conference center. Please enter your moderator code or your participant code followed by the pound sign. If you
Your passcode has been confirmed. Please wait while you are joined to the conference.
Mr. Chair, if you'd like, I can step out and try to ask Commissioner Gray to call back.
Please call in again.
Mr. Chair, this is Commissioner Gray. I'm sorry I was disconnected.
Yes, sir, you were by inadvertently.
I don't know if I was heard in concluding my position.
You were heard, I believe, and I was responding in a sense that I believe that you're right about all of our orders, but we rarely go back. I think that the reason for the request that the prospective review is to make it sort of a certainty that these issues are looked at again and any changes are made so that it's just not, it's more certain.
Well, Mr. Chair, I would say that the issue I feel most strongly about is, again, linking the LMI to the capacity. Some of the other issues that I have heard, I don't have sufficient information to feel strongly about objecting to the red line version, and therefore I've offered and rendered my support.
Call in.
Did you hear me, Mr. Chair? I'm sorry.
I did.
Okay, thank you.
Commissioner Drexler? What's your?
I guess, and I appreciate everybody's input, and I certainly appreciate all the work that, am I not on?
Well, if I just may interrupt, is Commissioner Correa on the line also?
Oh.
Okay, I'm sorry, go ahead.
Okay. I appreciate everybody's comments, and I am struck by how diverse they were in terms of issues, from disposal of solar parts and panels and monitoring that through its life, to the people that are affected, whose situations will be improved, who will participate, who who can benefit from solar, and I do appreciate everybody's input. My concern regards 16.2.3.1, and I think Mr. Moschella addressed this as a developer who, correct me if I'm wrong, sir, but you did indicate that as a developer you could pay this, but it does seem to be a barrier to entry in some cases that keeping the 16.2.3.1 section as is with, I believe, a $750 application fee wouldn't increase or affect the viability of applications or the applications by viable CF. So I think it just seems to me that going from $750 up to potentially for a 4 megawatt project, $100,000 seems like kind of a leap. And so that's my comment on that. I do agree with Commissioner Gray regarding the 16.3.3.4 that I believe Mr. Abbey discussed, and that was the 15% of members from LMI as a percentage rather than individually in terms of subscribers is also I think something that if it can be incorporated perhaps should be. That makes a lot of sense to me. I think Drew, the public advocate, will address again, and I would like you to clarify exactly what you'd like to change on that billing. And that regards, where are you? The billing costs, how you want that to be changed. You made comments about anticipated losses. If you could clarify those briefly for us, I would appreciate that. And that's the end of my comments. Thank you.
Thank you, Commissioner Drexler. I will be quite brief. The statute says any additional costs. My comment is that it should be stricken. That 16.10.4 should be stricken. I think that's the simplest way forward. I think that comports with the statute. I actually have an idea for a solution, but to be honest with you, if this stays in, I'm not sure that I can pursue that idea because I would argue that the regulations are not going to comport with the statute. So that's very brief. I have other comments, but I'll just address that one right now. Thank you.
You want to make those comments now, or do you want to wait till Mr. O'Brien speaks?
I'm happy to make them now, if you don't mind.
Please.
Thank you. So what we heard today was that this was a proposal or my comments were a proposal, a suggestion, or a new concept. And again, I just want to disavow that notion. This is what the statute says. I know, I was there. I actually wrote that language. But regarding net metering, I just want to be very, very clear. The Coalition for Community Solar Access, Sierra Club, and Delaware Solar Energy Coalition made it abundantly clear that this is not net metering. They did not want to fall within the net metering statute. So to treat it as such is a little different, and I can point you to their own comments on page 5, where they specifically state that any references to CEFs in the net metering regulations would be outdated and not reflect the legislative intent of SB2. So, they did not want to be part of net metering. Similarly, they didn't want to be part of a third-party supplier either. Regarding the low income based on capacity, I just want to make it clear that will mean that there are many less low-income customers on CEFs because it's based on capacity and not by size. And the capacity is about 18 or 20% of the actual size. So I just want to put that out there. This was not talked about, but, well, I guess it was pointed out. So Delmarva's comment in 16.11.7, I just want to point out that the statute already says that you shall review the financial health of the utility. It says shall, it doesn't say may, it doesn't say periodic. So I just want to make it clear that the statute already tells you that. And lastly, again, there was never a comment that these costs would be socialized. These distribution costs would be socialized amongst all other parties. There is a way, there is an avenue that I think benefits all parties, but I need this to be stricken.
I didn't quite catch that last comment, that there is a way, but then
Yeah, there's a way to do this, but to be honest, if the regulations go forward as proposed, I don't believe that they would comport with the statute. If it's taken out, then I think it does comport with the statute. And you can look at 16.10 by itself. I mean, they have the statute actually written in there, and then it goes to 16.10.4. So I would just say if it's stricken, then I just think that needs to occur. There is a path forward. There is, but it's going to require conversations and dialogue. And I don't know that I can have those conversations and dialogue if the regulations don't comport with the statute, as I see it. Thank you.
Mr. O'Brien, will you address that issue about the legislation, the statute, and?
Yes, staff does believe that section does comport with SB 2. The language Mr. Slater has cited says, further, the community-owned energy generating facility shall be responsible for any additional costs incurred by Delmarva, including billing-related costs associated with community-owned energy generating facility customers. So Mr. Slater did argue that staff's reading that to include only billing-related costs. That's certainly not staff's interpretation. It's just an example of an additional cost that the statute provided. And the proposed regulation uses the same language, just including billing-related costs. It doesn't limit it to billing-related costs. Staff just doesn't think that these bill credits are what's intended to be included as these additional costs. If you think about the bill credits that Delmarva will be providing on the bills, it is a socialization. I mean, I know Mr. Slater doesn't want these costs socialized, but there's no way around that. These are not additional costs, these credits. These are existing costs to run the distribution system. So when a subscriber to a CEF, let's say they're subscribed to 1,000 kilowatt hours in a month, and they actually use 1,000 kilowatt hours that month. That certainly doesn't mean they're not using the distribution system, but yet SB 2 adds the distribution side of the bill to what credits can be applied to. So by doing that explicitly, they're saying there will be a subsidy there flowing to these CEF subscribers, just like the subsidy flows to net metered customers who have solar panels on their roof. I mean, certainly you can see that when it's nighttime, when it's cloudy, CEF customers or NEM customers are certainly using the distribution system, which is largely a fixed cost for Delmarva. Now, they do collect it as a per kilowatt hour charge or volumetric, but it's still largely a fixed cost. So there will be a subsidy here to comply with Senate Bill 2 by allowing these offsets on the distribution side. So how do we read this language to allow for that? These aren't additional costs. It's a reallocation of existing costs on the system. It's a reallocation from customers who are now not subscribers to the entire customer base through however Delmarva proposes to collect it. Whether it's collected in a rate case, like it currently is for net metered customers, or whether it's collected with a surcharge based on a tariff filing that they'll be making in the future that the parties will all have a chance to challenge or not challenge. There is a subsidy here that we all thought was clear through the forums and through the stakeholder processes coming up with Senate Bill 2. So to hear that there is no subsidy because an additional cost includes the billing includes the billing credits, again, you heard two people from the solar development community say that would ensure that no projects will be built. Because it gives on the one side and then takes it away on the other side. There's no business model that would survive if the CEF has to pay for all the billing credits that it's providing by producing electricity. So it's just a difference of interpretation of what is meant by additional costs incurred by Delmarva. But also it's an interpretation that allows for the other change to this statute to have meaning. If you read additional costs as meaning the distribution bill credits, then the new language on the other part of Senate Bill 2 that allows for offsetting on subscribers' bills on their distribution charges has no meaning anymore. Because the CEF, of course, is just going to have to pass those costs on to the subscribers. So that's staff's reasoning. If the commission finds that additional costs includes the billing credits and it ends the program, then I suppose we'll perhaps see legislation to fix it. If you agree with Mr. Slater, then I guess that's the route we're going to go down. But staff doesn't think we need to go down that route because it reads additional costs as only those incremental costs caused by the implementation of the program itself. For example, billing-related costs. There are other types of costs. Certainly, if they're getting so many interconnection applications that they have to hire temporary help to process all of them, that would be an additional cost caused by this program, just like upgrades to the billing system, which is actually mentioned as an example. But to call billing credits an additional cost essentially wipes out the subsidy that virtual net metering or actual net metering provides.
Mr. Slater.
That's the first time I've taken off a mask that way. I'm not entirely sure where to start. The only part I think I agree on is I do think that this will require legislative change. It will likely require one because clearly there is a difference of opinion on this issue. It will likely require a legislative fix. It will be eerily similar to Reg 56, which was the same thing. It required a legislative fix. Perhaps it needs legislative clarity. That's why I would suggest we remove this language as it stands and move forward with a legislative fix with all the parties. I think that's abundantly clear. Part of the issue here is that the regulations tell Delmarva to file a tariff that the statute doesn't tell them to file. I don't know what's going to be in the tariff, but to me it seems kind of like a blank piece of paper to file whatever you want. I don't think that comports with what the statute meant.
Thank you, thank you, Mr. Slater. Commissioners, we got to do something at this point in time. I would ask if Commissioner Correa, Mr. Gray, or any of the other commissioners have some motion that they want to make as a result of hearing all of the stakeholders speak today to change what is in the existing document, to raise your voice now and make the motion so we can make that change that you believe is appropriate, including a motion to make the change that Mr. Slater is arguing for. Otherwise, I'm going to make a motion to approve the present document, and with the knowledge that, as Mr. Slater points out, the statute requires us to revisit it, and that these issues can be in fact revisited, and as Mr. Slater points out, the legislature comes into session in January, and the working group is still working. They can address this issue and then go jointly to the legislature. But I do think we need to put this thing to rest and make a decision. Is there any motion that a commissioner would like to make?
Mr. Chairman, I concur, and I would like to make a motion to, I'm not seeing the order number.
Commissioner
A motion-
Drexler, there's no proposed order
Right.
because the order's going to need to reflect what went on today and any
Okay.
changes that might be made. And it's also going to come after the end of the public comment period, which according to the APA must be 15 days past the hearing. Staff did ask to respond to any proposed changes. So if it please the commission, we can provide our reasoning on the LMI subscribers being measured by number of subscribers versus the capacity of the system.
If there's a motion on that, we can have some discussion on that, but I don't
think-
hear a motion coming so
Okay,
far.
I
think
thought
the
it was coming.
I think the DPA's comments address that.
Thank you.
Yeah. So I would make a motion to accept the proposed regulations as presented.
Is there a second?
I second the motion.
Okay, is there some discussion on the motion? Commissioner Gray, do you have any questions or any expressions you want to give about the motion?
Thank you, Mr. Chair. So if I were making this motion, I probably would have made the motion to adopt with the one revision to link the LMI to capacity and not subscribers.
That's not a friendly, amendment to the
That's
motion.
not the motion, but that's not the motion on the floor, and I'm not going to offer a friendly amendment. I'm going to express my support to Commissioner Drexler's motion.
Any further comments? We'll have a vote then. Commissioner Correa?
I vote yes.
Commissioner Conaway?
Yes.
Commissioner Drexler?
Aye.
Commissioner Gray?
Aye.
And I vote aye, the motion carries. Thank you very much, everyone.
Mr. Chair,
Yes, Commissioner.
having sat in this seat for 20 years and been through several rounds of things like this, I would just like to warn you all that there are groups forming out there who don't want these solar panels in their neighborhoods. It's like Blue Water Wind, it's like Bloom, it's like everything. Ocean City. So please, let's get educated as to what they do and don't do so that we can talk to these people. Please.
Well, we'll be happy to talk to them and listen to them, but the bottom line, as far as I'm concerned, and of course, I think Mr. Slater has his eye on the ball like this all the time, as I think all the lawyers do, and that is there's a statute. And we're going to try the best we can to follow what the statute says. And so some of those arguments are certainly just not relevant.
Oh, tell me about it.
Those policies have been made. Those policies have been made, and so Mr. Nichols speaking today, I know he's got some pretty strong opinions about these sort of things, but the legislature's already spoken. So now, we do have some administrative matters, but before we do that, I see one of my favorite lawyers in the room, and Ms. Iori, and she hasn't spoken today one word. And I would ask her if she would be kind enough to come to the table and have a seat and take her mask down so she can speak. I'd like to ask her a couple of questions. First of all, No. First of all, you weren't here when I praised you. I just want you to know that
I'm not
you're-
getting any sound from the chamber.
Huh?
Can you hear me? Okay. The bottom line, I said, first of all, I, in your absence, and I should have waited for your presence, I praised you. And I told you, I said that your brief on the edit issues was excellent. It was 25 pages. I read every page, every footnote, and I just call it the $1 million brief. So I thought it was very good. But would you be kind enough to tell us what the issue was at the Supreme Court and just a real nutshell what happened?
Sure. The issue was, as the commission probably recalls, Chesapeake had come in with a proposal to acquire.
I am here, I can hear you, but I can't hear anyone from the chamber.
Yeah, okay.
Can you hear me now?
Same with you.
Is this the chamber where Commissioner Correa and Commissioner Gray are not hearing anything from the chamber? It's dead silence. Are we in connection again?
Can you?
I can hear you now, so whatever you're doing,
Yeah.
try not to change it.
Okay. As the commission may recall, Chesapeake Utilities filed an application to acquire community gas systems owned by its unregulated affiliate, Sharp, and to convert those to natural gas. And so they were seeking not necessarily approval of the purchase, but approval of the proposed rate-making treatment once those community gas systems were converted to natural gas systems. And so we went through the proceeding, and about a week before and we reached a settlement agreement, and about a week before the settlement agreement was scheduled to be heard by the commission, the Delaware Association of Alternative Energy Providers, which I'll call DEP, threw a monkey wrench into the proceedings, shall we say. They never tried to intervene throughout the proceeding. Instead, they tried to file a complaint, a formal complaint, in that docket. They complained that they were not able to because Delafile went down, so that Mr. Hardigan said, okay, he would file it for them in that docket. That caused an uproar from the DPA and staff and Chesapeake, saying that a formal complaint is a separate docket. So ultimately, that was how it was docketed, as a separate docket. The commission heard testimony on the settlement agreement and approved it. The commission also allowed DEP to provide public comments on it, even though they had not provided any public comments by the deadline, of which they were well aware because I had provided their counsel with the scheduling order. So, then the next week, the commission, I'm sure it shouldn't say next week, at a subsequent commission meeting, staff, DPA, and Chesapeake had filed a motion to dismiss DEP's complaint on the grounds that the relief that they sought, which had to do with the docket in which they were not a party, was moot, and that they lacked standing, and that they caused their own problem by not trying to intervene. Regardless of whether the commission would have said no or not, then they would have been a party and they could have appealed it. And the commission granted that motion to dismiss. So that is the order that was on appeal today. And so it was not what I would consider a particularly hot court. DEP's lawyer spoke for probably 7 or 8 minutes before getting any questions. And Justice Traynor then began to ask him questions about, well, you knew about this, didn't you? Why, you waited until a week before the hearing. Why didn't you move to intervene? And, DEP's lawyer gave the answers that one would expect him to give when asked why he didn't do something so simple. And it basically said that, well, the other parties would have objected to it and the commissioners probably wouldn't have granted it. And Justice Traynor said, well, that's kind of the process, isn't it? And then you could have appealed that order. So I think we have him. Justice Valahura was also on the panel. She didn't ask their lawyer any questions. And Justice Montgomery Reeves was the third justice on the panel. And she asked Depp's lawyer, if instead, I forget what it was now exactly, but anyway, then Brian Quinn got up to argue for Chesapeake, and by agreement of the three appellants, Brian was going to handle most of the argument, and Jim Geddes was going to handle the commission-specific things. And so Brian, I think, did a really good job. Justice Valahura asked him about Frank's complaints about the public comment, and how were we supposed to file a public comment on a settlement that didn't get filed until 2 months later, when one of Frank's arguments was, well, the commission didn't have the jurisdiction to enter that order in the first place. So kind of, there's a definite contradiction in logic there that I guess nobody really pointed out to Frank. We did in our briefs, but in any event, so Jim addressed that when he got up. The only other question that Brian got asked was by Justice Montgomery Reeves, and she said, well, what about if we just decided this on the ground that he should have intervened, or he should have tried to intervene and he didn't, so that he would have had a direct right of appeal? And Brian said, well, certainly you could decide it on that issue, but this issue is going to come up again and again if that's how you do it. And the next time it comes up, we'll probably just be back here again in front of the Supreme Court. And this time it will be, the jurisdictional or the standing issue. So we think that the commission would really appreciate it if you would, give them some guidance on this. So the court took it under advisement, and under the court's internal operating procedures, they should have an opinion out to us within 90 days.
Thank you very much. Appreciate that update.
Thanks, Chairman Winslow. So our next meeting will be Wednesday, December 1st. You'll be happy to hear at that meeting we'll have another evidentiary hearing. Perhaps not as long, but that will concern Delmarva's RPS compliance charge. So with that, I just wish everyone a happy Thanksgiving.
Yes,